Michigan court rules. Other cases decided thereunder to the extent a conflict does exist. Given the waivers, the court will consent to hear the matter. Court does call the case of the People versus Jenny Liu.
Ashley Lonnie for the people.
Michael Getty, Assistant Public Defender on behalf of Ms. Liu, Judge, who I believe is present here via Zoom.
Yes, she is. Ms. Liu, can you state your name, please?
Yes, sir. Jenny Liu.
Thank you.
Your Honor, I believe we have a resolution in this matter. I have had a chance to speak with Ms. Liu. I believe upon a plea to attempted resisting obstructing in case 23F10628, that the felony in that matter will be dismissed and the matter 24F10014FY will be dismissed in its entirety.
The plea sheet that I have indicates she'd be pleading no contest to an added count 2 of attempted resisting and obstructing a police officer in 1-year offense.
That is
on her successful plea. Count 1 in that case would be dismissed, as well as the case ending in 014.
yes, Your Honor, and I have had a chance to meet with her, and I did go over her rights. She understands those. She is a U.S. citizen. There are no PDA issues. Is that correct, Ms. Liu?
I don't need to know that.
Oh, I'm sorry.
Yeah.
Judge.
All right.
That is a correct recitation of the plea agreement.
Okay, very good. Ma'am, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
All right, state your name again, please.
Jenny Liu.
All right, you can put your hand down. Ms. Lewis, it's court's understanding that in the case ending in 0628, that you're going to be pleading to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. Do you understand that?
Yes.
All right, do you understand what a no contest plea is?
Yes.
All right, 2 things about it I have to make sure that you understand. The first thing you need to understand is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Mr. Getty, the basis for the no contest plea.
I'm sorry, Judge. Potential civil liability.
Ms. Liu, to the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Did you want to plead no contest, Ms. Liu, like we discussed?
I thought that's what it was.
Well, no contest is.
So am I
since
saying
you're
no
not
contest?
If that's how you want to plead, yes.
Okay, yes, sir. Can I say no contest?
All right, let's do. You want to do over. All right. So to that charge, how do you
Please.
plead?
No contest.
There you go. Now you understand that by pleading no
Apologies.
contest, you will not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for your trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
You are not. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided and has reviewed Michigan Department of State Police report for their case number 1957-23. Any objections to the court having reviewed that report?
No, Your Honor.
None from defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this case. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
Court will accept the defendant's plea to count 2 in the case ending in 628, and count 1 in that case is dismissed, as well as the case ending in 014. That case is dismissed. This is a victim of rights case, so.
It is, Your Honor.
Pre-sentence investigation and report is ordered at 14A probation. Sentencing in this matter will be
June 11th at 9 a.m.
June 11th, 2025, 9 a.m. before me. Bond will continue in this matter. Okay.
Thank you, Your Honor.
Thank you, Ms. Liu.
Thank you, Your Honor.
Okay, so on June 11th, what's gonna happen? I'm coming back.
Yes, you'll come back and I'll impose sentence. I can't do it today because the victim has to be contacted in case. And so otherwise I would sentence you today. But yeah, you'll come back on the 11th.
All right, Your Honor. Thank you.
All right, thank you.
I'll talk to you before then, Ms. Liu.
Okay.
Court calls the case of the People versus Jacob Dorston.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Dorston, who is making his way to the podium, Your Honor.
Your name, sir?
Jacob Dorston.
All right, what are we doing on this case?
Your Honor, Mr. Dorston would like to set this matter for preliminary examination. We have had discussions with the people, but he'd like to set this matter. Discovery is complete to the best of our knowledge.
So he's not requesting the adjournment on the,
Oh, no, Your Honor, that's my fault.
well, no, that was from last time. I'm sorry.
Oh.
All right. So all discovery is complete.
Yes, Judge.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Freshour.
Thank you, Judge.
Bond will continue. I need that.
10 o'clock.
27th, before Judge Freshour. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Kennedy Braddock.
David I. Goldstein appearing on behalf of the defendant.
All right, thank you.
That wasn't me.
I know.
This time.
This time. All right.
Your Honor, we've executed a waiver form. We're going to be waiving exam seeking resolution in circuit court.
Is that correct, ma'am?
Yes.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yeah.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yeah.
People also waive the right?
Yes, ma'am.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of information in this matter. My client waives further reading, stands mute, asks that a not guilty plea be entered.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 9th at 1:30 p.m. with Judge Conlon.
July 9th, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Anthony Flanagan.
Joseph and Colin, the people. David I. Goldstein appearing on behalf of the defendant.
Your name, sir? Anthony Flanagan. Thank you. What are we doing?
Your Honor, as the court is well aware, there was a competency evaluation done in this matter. We are now going to be asking for an evaluation on criminal responsibility, but we'll do that in circuit court. So we're going to waive exam.
Okay. All right. Is that correct, sir, that you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
All right. You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
People also waive their right?
We do, Your Honor.
7, 6.
Your Honor, we acknowledge.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 through 5 with 6 following. Go ahead, Mr. Wilson.
Your Honor, we acknowledge receipt of the information in this matter. We waive its further reading. My client stands mute, asks that a not guilty plea be entered.
Defendant having waived formal reading, standing mute to all 6 counts, court will enter a not guilty plea. Pretrial will be set for
June 3rd at 1:30 p.m. with Judge Conlon.
June 3rd, 2025, 1:30, Judge Conlon.
You're all set.
Bond continued. Thank you. Court does call the case, people versus Corey Craig.
Come in. Okay, I was out in the hallway.
Alexander, we have
David I. Goldstein, appearing on behalf of the defendant.
Your name, sir?
Corey Craig.
All right. What are we doing?
Your Honor, I was prepared to ask the court for an exam date, but I was informed this morning when I got here that there may be some media that has not been provided as of yet.
And that's correct, Your Honor. I did put in a request for media discovery yesterday as well for the 911 call. I have not received that.
All right. And what time would you be available? 29th?
Oh, I'm looking at the 27th for some reason. Yes, Your Honor.
All right. Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond will continue.
Thank you.
Court does call the case of the people versus Haley Gregg.
Good morning, Your Honor. Great to see you. Christina Costantino appearing with and on behalf of Haley Gregg.
See her over there. Your name?
Haley Gregg. Judge, this is a date and time set for a PCC, and we have reached a resolution in this matter. I do have a plea agreement if I could present that to the court.
Okay, so how am I going to accomplish this?
Do you mean because it's a no contest plea? Or
Yeah. And I don't have a report.
I do have a clean copy of the report if I could also present that to the
So
court.
I'm supposed to read that now.
I know, Judge, I apologize.
Okay, the plea agreement indicates that she's going to be pleading no contest to the charge. The maximum penalties on here either.
that would be my fault.
Judge, if I could, the maximum possible penalty is 1 year.
Maximum fine.
That one's a good question, Judge.
It's $4,000.
That it was. 1,000 on the attempt. Yeah, we're rolling along in that.
Sorry, Judge. I had to come along and
Home and
mess
I was
everything
blaming
up.
both of them all day for this,
So
not you.
sorry.
You're good. This is not your fault at all.
No, it's not.
I am looking at the attorneys that don't seem to be ready.
Very sorry, Judge. Very sorry.
What's the maximum, well, hang on, folks. The maximum penalty on this is going to be, give me the max on unlawful use and just cut it in half.
My understanding, the max on unlawful use is 1,500.
It's
However,
1,500.
It says if the case is a first offense, the court may reduce the punishment for imprisonment or the fine of not more than $500. So the maximum would be 1,500. The court could, of course.
On the
do more.
principal charge, it would be
Yes.
1,500, which means on this attempt, it's 750.
That would be
All
my understanding. My math is not great, but it seems right.
Has she signed an advice rights form?
Judge, I'm sorry.
But let's see. We called one case of Constantino's and I could have done like 8 cases.
I know, Judge, I'm so sorry.
No, it's okay.
It is up here.
I
It's hard to
have,
get the
I have no
signature when they're in custody.
problem waiting. I don't think the rest of these people have that same feeling.
I understand. I apologize to all of my colleagues. Need you to sign this as well. Can you just sign there?
Heather? Okay. All right. Are we finally ready?
I think so, Judge.
Yeah, let's see. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Haley Gregg.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of attempted unlawful use of a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration and a $750 fine plus court costs. You understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right, 2 things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. Hear me?
Yeah, I can hear everybody else.
Okay. You understand that it means that you're not willing or wanting to contest this charge.
Yes, I do.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? You understand also that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Perry in the 15th District Court.
Yes, I do. Your Honor.
All right. Now understand, and the basis for the no contest plea.
Potential civil liability.
Understanding all of that, do you still wish to plead no contest?
Yes, I do. Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I am.
All right. You signed an advice of rights form, is that correct?
Right.
A question regarding any of those rights? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up, pleading no contest, you're giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yeah.
Of your own free will? And because you believe that you are indeed guilty, or I won't ask you that. Never mind. Court has been provided Ann Arbor Police Department report for their case number 25-17-355. Any objection to the court reviewing that report to form the factual basis?
No, Your Honor.
Based upon the review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt. To the defense counsel, have I complied with the court?
You have, Judge.
Yes, sir.
Court will accept the defendant's plea of no contest. 2 count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
June 6th at 10 a.m. with Judge Perry.
June 6, 2025, 10 a.m. before Judge Perry.
Thank you, Your Honor.
Thank you.
Would the court allow me to address Ms. Gregg's bond?
Sure, let's spend all day on this. Go ahead.
Sorry, Judge. Your Honor, her bond is currently $5,000 with a 10% provision. She's unable to post that bond. That bond was set in mind with this charge being a felony. She has now pled to a 1-year misdemeanor. She spent the last 50 days incarcerated. Should she be released, she does have stable housing. That would be in Ypsilanti with a friend. She does also have employment lined up as well, should she be released. We would ask if the court would consider a personal bond. She's also been in touch with community mental health, and she will be working with them upon release.
Response.
Mental health, we would not have done it to the lower bond because it's in the district.
Okay, I will for bond to a $5,000 personal recognizance bond. Defendant, and with the condition to maintain contact and communication with community mental health. Okay,
Thank you very much, Judge.
you're good.
Oh, yeah.
All right. follow through on everything.
I will.
You hear me?
Yes, I will.
All right,
Thank
thank
you.
you.
Thank you, Judge.
Court does call the case of the people versus Antoine Pitts. Speak French again. Antoine Pitts? Really? So is there a prosecutor on this too? Wait, what? Is this your case?
Well, you know, the two of us are looking at each other like, who, what? David I. Goldstein, appearing on behalf of the defendant. I didn't have this on my calendar for some reason, Judge. Neither did she.
All right.
Your Honor, I received a email from Mr. Pitts last night. Apparently, he's having a medical problem. He did send me a medical letter indicating he's been ordered for bed rest and oxygen. I'm trying to find it so I can show it to the prosecutor in the court. Here we go.
Well, when did that happen? Because I issued a bench warrant for him without bond because he has not done anything at community corrections.
That was within the last couple of days, Your Honor.
So this bench warrant was ordered before that. Back in the earlier part of May. He's not been in contact with them.
I will, I did see some kind of a bond violation report, Your Honor. And that's why I assumed it wasn't on today because the warrant had been issued, so.
I'll leave the bench warrant outstanding and then he's having a medical issue. You can send it in a recall and I'll look.
Well, I'll get in touch with him. We'll figure out what's going on.
All right.
Thank you.
Thank you. Let's call the case. People versus DeBassier Hennings.
If you were to get the people.
This will go much smoother. Christina Constantino on behalf of
I do
Mr.
not believe that to be true.
Mr. Headings, can you please state your name for the record?
Devasier Henning.
Thank you.
Judge, this is a date and time set for our PCC. We have just recently, as of yesterday, received some additional discovery that has led me to believe that there is some additional outstanding discovery. So given that, we would be asking for an adjournment of the PCC.
We do have a great sheet.
I do.
Oh, we're sharp here.
See, I told you it'd be smoother.
Mr. Headings said we were actually on the 3 p.m. block with Ms. Markwell. I saw her actually in courtroom 2 minutes ago though. So I just wanted to make the court aware that it's going to be here much later today.
All right. June 5th work for you? Well, I can do the 29th. Will that be better?
If we could do the 29th, that would be great.
Probable cause conference, May 29th, 2025, 9 a.m. Bond continue.
Thank you very much, Judge. Have a good rest of your, out of your hair.
You're done?
I'm out of your hair.
Really? You're done. Took up 4 hours and now you're done. All right, have a great day. Time I don't get back. Court calls the case, people versus Reno Save.
David I. Goldstein, appearing on behalf of the defendant. Your Honor, the defendant is not present. He can be on Zoom if necessary, but we had already been notified this matter was going to be dismissed prior to today. I believe that Ms. McDuffie has an order for the court.
Well, is that correct? It's going to be dismissed?
That's right.
No objection?
No, Your Honor.
Case is dismissed. Is he in Zoom? Mr. Ave, sir, state your name.
Yeah, good morning, Judge Reno Suave.
All right, your case has been dismissed. I'm assuming you don't have any objection to that.
No, sir.
All right. Have a great day, sir. Thank
Thank
you.
you, Judge. Appreciate it.
Court calls the case, people versus Cedric Johnson.
Your Honor.
Morning, Your Honor. Edward Lucas on behalf of Cedric Johnson.
All right. Your name, sir?
Cedric Johnson.
All right.
At this time, we'd like to set this for a preliminary examination
All right, he does have the bond violation.
for the new case.
Was there another case coming?
There's another case that he's got
Pardon?
he has a misdemeanor charge that came through from, that was the bond violation in this case.
This is the one where he is a double contact.
That's correct, Your Honor. There's a misdemeanor count of BV in 1482.
But that's not considered a violation of this one?
No, it is, Your Honor. He was arraigned on that case on 5/12.
We just did an arraignment last week to get this date. Or was it when was our arraignment?
It was on.
The arraignment was on Monday this week. And he got this PCC date to go in front of you.
Right, but there's a bond violation, is what I'm indicating.
If the court has it. I mean, I'm in receipt of
understanding that there's a new case that I would anticipate being that bond violation. Because he wasn't.
Well, I don't know that. He was arraigned on a
He also failed.
bond violation.
He failed to show up at the exam.
That case is the bond violation.
Okay. Well, what am I gonna do with the bond violation at this point? I mean,
It's difficult to address if he's got a pending case. And the,
well, at this point, his bond is revoked in any event, so it's gonna be revoked. You want this set for preliminary examination? Why is this one listed? Was this my case? No.
it was previously,
Set before,
yes, it was an exam that was set. And
that's what I thought.
failed
It was
to-
set before me.
That was on 429.
yeah, he did turn himself in last Sunday. He had the mix up of the court.
So all discovery is complete.
Yes, Your Honor.
People have their witnesses available. My next date is June 3rd. Preliminary examination will be set June 3rd, 2025, 9 a.m. That's before me. Court calls the cases of people versus Areli Zara Vilchis.
Ashley Lonnie for the people.
Good morning, Judge Lawrence H. Margolis, and on behalf of Mr. Raza Vilchis, Ashley Zarelli, please state your name.
Good morning, Judge. Areli Braza Vilchis.
Okay, what are we doing?
Judge, it's the first, I believe we're waiting on some discovery. I'm asked to adjourn it, and I would defer to the prosecutor as to the time she would like.
Your Honor, there is outstanding discovery, specifically the autopsy, as well as the lab results. So that's going to take a little bit of time. I can't say with any definitive
Understood.
facts how long, but it's gonna take at least a few weeks, I would think.
Probable cause conference will be adjourned June 12th,
Maybe people be heard on bond.
2025, 9 a.m. Yes, that's the bond.
Your Honor, could the court inform us how many times the defendant is testing per day? She's on a sober link. I couldn't quite tell if she got a sober link or a scram.
So she had,
I have her on a location tracking. I think I have her on a scram.
Excellent. Thank you, Your Honor. Nothing further.
Bond will continue with its conditions. Thank you.
thank you, Judge.
Court calls the case people versus Danielle Landeman.
And on behalf of the people, Your Honor.
Carolyn Foster Tucker on behalf of Danielle Lampman.
Danielle Lampman.
Thank you. Yes. All right. Record should reflect we had a bench conference. What are we doing on this case?
Your Honor, we're requesting a preliminary exam,
And all discovery is complete.
to my knowledge.
We'll have the witnesses available the 27th. Preliminary examination in person, May 27th, 2025. 9 a.m. That's before Judge Washington. I will also execute an order that defendant, to the extent we can, her mail privileges or ability to send mail will be restricted. I'm just not sure how that's gonna look. But we're gonna shut down her potential communication with the alleged victim, in this case, the best way we can. All right. Thank you. I'm gonna need an order that says that kind of. Court calls the case, people versus Michael Hill.
Good morning, Your Honor. James Fifelski on behalf of Michael Hill, who unfortunately is not here. I just went out to the hallway to check to see if he was present and did not see him. I've called him a couple of times and wasn't able to leave a voicemail message. So just for the sake of the record, I would ask for one brief adjournment.
He already has a bench warrant out.
Okay.
So his failure to appear, I'm just gonna leave the bench warrant out.
What, is there a bond set on that or just a
He has no bond.
no bond? Okay. Thank you, Your Honor.
Court does call the case, people versus Angelica Towers.
And then on behalf of the people, Your Honor.
For Angelica Towers.
Angelica.
Thank you. All right, what are we doing?
Your Honor, there's some negotiation and I'm asking for an adjournment today. I'm asking for a short adjournment. And I understand that the bond violation,
Pardon?
maybe a bond violation as well.
Yes, violation of her no contact order.
That's correct. I have the understanding, I was contacted by the complaining witness in this case. I was told that he had spoke to the victim advocate, two of them, and he would like to address the court today
For what reason?
to allow contact.
That is correct. He is here to request contact.
In light of the bond violation? I'm not gonna do it that way. I mean, there was I have an alleged bond violation. I have somebody coming through wanting contact. Okay, I don't. What I will do, probable cause conference, I will adjourn to May 29th, 2025, 9 a.m. I will also set it for a bond violation hearing at that time. And then I'll hear from the parties. So actually that's, yeah, on that day. For probable cause and the bond violation here. Bond at this time will continue. Thank you. Court does call the case People versus Julia Sosinski.
Ashley Lonnie for the people.
Your Honor. James Fifelski on behalf of Ms. Szynski. State your name for the record, please.
Julia Sosinski.
All right, I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of use of heroin, a one-year misdemeanor. Upon a successful plea to that charge, the felony would be dismissed. There's also the agreement between the parties of no 7411, delay or deferred.
That's correct, Your Honor.
That's correct, Your Honor.
Ever sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give, the whole truth and nothing but the truth, so help you God.
Yes, I do.
State your name.
Julia Sosinski.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of heroin. That is a misdemeanor punishable by up to 1 year incarceration of $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
Yes, Your Honor.
All right, understanding all of that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of April 3rd, 2019, location of US 23 near North Territorial Road, Northfield Township, Washington County, State of Michigan. Did you have heroin in your possession?
Yes, Your Honor.
Did you use it?
Yes, Your Honor.
And did you know what you were using was heroin?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Before satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
June 16th at 9 a.m. with Judge Freshour.
June 16th, 2025, 9 a.m. before Judge Freshour. Bond with its conditions will continue. Thank you.
Thank you very much, Your Honor.
Court calls case People versus Larzell, Washington.
Good morning, Edward Hughes on behalf of Rizal, Washington.
How you doing, Your Honor?
I'm doing great. What's your name?
Larzell in Washington.
Thank you.
Thank you, sir.
Your Honor, we had referred this over to the recovery court. I spoke with them and they indicated that they've in receipt of all the information to do an intake. However, they have not done that interview. That interview could be completed within a week. Like if we could have a 1-week adjournment.
Probable cause conference, May 22nd, 2025, 9 a.m. Bond continue. Court calls case People versus Marquise Fab.
Oh, excuse me, sir. Yeah. Can I please have a word? With all due respect.
I think Mr. Washington would like to address bond.
Excuse me.
Go ahead.
How you doing, Your Honor? My name is Larzell near Washington. First and foremost, forgive me about my outbreak last time I was here.
Can I have that file?
Go ahead. Thank you, sir. What happened was, I wasn't aware, as my attorney indicated, what day was my probable cause hearing was. Okay, I went back to the magistrate. They said, no, well, we're gonna let Judge Simpson handle it. Then last time I came here, it was a 2-week hold because they didn't do their job. I feel I shouldn't have to be.
Who didn't do their job?
What you say? You gave him a plea.
The recovery court?
Well, I didn't ask for no recovery court, but whatever assessment you gave him, it was 2 weeks. And the honorable judge said, okay, well, I'm not going to change his bond. Now, you still didn't indicate I was looking for a bond. And I wasn't even aware of a drug war. So with all due respect, I do appreciate you, but I did unfortunately miss my court date.
Right.
I was,
And then how'd you come into custody?
oh, I came into custody? What, trying to, being a good Samaritan. Some woman was being stalked and they figured out what my name was. And I totally forgot. I really didn't know what court date it was. And I was disciplined for the first, and in discipline, well, not necessarily discipline, you allowed it to, override until they took care of their own situation, but it's not my fault.
So who is they?
Would you explain to him?
Well, I think I got to collect more of that story.
Okay, you gave him a piece of paper about assessment along with a plea.
Mhm.
Okay, I get here today, the assessment I took care of. Right?
You just want them to speed up the process.
No,
I
it's
think
not them. It's not his fault. He's a judge.
Mhm.
Thank you. Thank you. Thank you. Thank you. Thank you. That's right. Nothing is my fault.
No, it's not.
That's right. I know.
Amen. So I'm saying, I'm just trying to, sir, live my life. I normally work carnival shows. I have really been disciplined for not being aware of to show up. I'm not dumb enough not to show up again.
Excuse me one moment. Whose phone is that? It's somebody down there's phone. Is hers? Tana's phone? Really? Go ahead, sir.
And I'm not ignorant enough not to show up in front of Judge Simpson courtroom again.
I think he is saying that he would show up to court next time. He's asking for a PR bond.
Yes, I am, sir.
If the court would not provide a PR bond at this time, if the court would allow an interview to take place, if that interview takes place, then the court provide a PR bond.
I never said that. I asked, could you please provide a PR bond? And I will.
I addressed this the last time you were here.
What was it about?
I think they're gonna keep you in.
All right, man, you're fired. God bless you. And thank you, Your Honor.
Why is he fired?
Because he's not speaking up for me. I really don't even know what's going on.
Oh, it would, okay, so does he understand before you make that final decision about firing him? It
Well,
wouldn't have mattered whether you spoke or he spoke. I'm denying your motion. I've already
okay.
heard it.
Well, I don't know. Why are you denying the motion? And what's so funny?
Because,
Wow.
because you appeared here, didn't show up, didn't turn yourself in, got picked up, got brought here.
Yes.
That's how we got you back.
And the
So I'm
magistrate,
not releasing you
right, the
now.
magistrate
Okay, so
did not release me. And then
that's right.
you didn't release me
That's
because
right.
you wait for assessment. Am I
And I
correct?
haven't had the assessment yet. have I?
Exactly. So is it my fault you haven't had assessment? Is it your fault?
It's my fault? I thought nothing was my fault.
So whose fault is it?
I don't know.
But it's not mine. So you do agree.
No, I don't agree.
The assessment, do I?
I don't know whose fault it is. It hasn't happened. I'm done.
Pretty much. God bless you.
Thank you,
Thank you.
Thank you, Ron.
Well, keep talking. Why are you up here at my, why are you at my podium? Why are you at my podium? Next time, Tana, turn your phone up louder when that's going on.
And then it was.
Did I call your case?
Yes, you did. You called, Mrs. Bath, Marquis Bath.
Oh, that was so long ago. You're right. You are right, Miss Cannon. And I usually criticize you for not getting up here on time. And I have to give you credit that you're like early.
Got it, Judge.
Court calls the case, People State of Michigan versus Bath.
And then on behalf of the people, Your Honor.
Stephanie Cannon, on behalf of Mr. Bath, who should be appearing by Zoom. Oh, thank God.
Mr. Babb?
Please be there. So what had happened?
Marquise Babb, you need to unmute and turn on your camera. Every week, Cannon. Every week.
I was doing my part today. Your Honor, we're just setting it for a preliminary exam.
What?
We're simply setting it for the preliminary exam.
I gotta have him, I don't know who, I gotta have him here. Oh, you're just gonna call him?
Yep.
Never mind. I'm gonna say something. This is practicing law by janaza. That's what you're doing right now. This is,
Great, he got it.
yes, acting really, this is so you. You're like, what? Oh, uh-oh. Mr. Bab?
Yes, sir, Judge.
All right, you got your camera on?
You need the camera as well?
Yes, yes, Mr. Babb.
That is his camera on.
Yes, it's already.
Is that Mr. Bab?
That's Mr. Babb, Your Honor, yes. The good news is he'll be here in person the next time, Your Honor.
I won't be here to witness it. It's going to somebody else. All right. All discovery is complete, Ms. King.
Yes, Your Honor. Discovery is
People
complete.
have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Fresh Hour.
Thank you so much, Your Honor.
Thank you. Bond will continue. Court calls case of the people versus Marvin Sullivan.
Andrew Childress, appearing on behalf of
James Fifelski appearing on behalf of Mr. Sullivan, who is approaching. State your name for the judge, please.
Marvin Sullivan.
Thank you. Your Honor, this is the first PCC. I'm asking for an adjournment for discovery and investigation. So I can review discovery with my client, and if I could possibly address bond, I would appreciate it.
Probable cause conference, May 29th, 2025, 9 a.m. I need a screen sheet.
Your Honor, I know you hate it when I do this, but I actually have a trial in Wayne County that day. Could we do the 3 weeks out?
June 5th.
Thank you very much, Your Honor.
2025, 9 a.m. Esteban.
Your Honor, it's my understanding a $10,000 bond has been set in this case. My client has a lot of family in and around Romulus. He would reside with his mother in Romulus if he were bonded out. Has been gainfully employed doing demolition work out in Detroit, has 3 kids, custody of, I think, 2 that are in Michigan. And to my knowledge, I haven't had a chance to verify this, but it does not have any prior convictions involving firearms or assaultive activity. And I believe that while he has another pending case, that case has a PR bond. So I would ask the court to consider a low cash bond.
What's his other pending case?
No,
I'm not sure.
they got up to driving without ops on the person.
Maybe a misdemeanor case?
So he's got another weapon charge.
Apparently so. I don't know anything about it, but it has a PR bond, so.
But that case preceded this one. And then he picks up this one.
I don't know.
Actually, the other case that he has is the other issue is that the defendant does have an extradition warrant from Mississippi. And we haven't, and I did verify, I spoke with Ms. Burton Harris yesterday about this in our office. We're awaiting the actual governor's warrant of Mississippi, but we can verify that there is a warrant for an out of Mississippi.
But we don't have the governor's warrant yet.
Correct. And so there is a CCW, Mr. Sullivan has a pending CCW charge now, 8/27/2022. And then the facts of this case, I believe, false. So that the older CCW, which is still pending, predated this offense. Mr. Sullivan does have a prior CCW conviction under HIDA, 2012. And obviously this case involved possession of a firearm and shooting it in the vicinity of a Washington County Sheriff's deputy who was training canine in the back of the parking lot. It's not charged with, it wasn't charged with shooting at that deputy, but the reason this came to law enforcement's attention was the deputy was training his dog, heard gunshots and saw a car drive off. And our allegation is that it was Mr. Sullivan who was shooting, basically testing out his new gun that he shouldn't possess in the vicinity of the deputy. I'd ask the bond, frankly, the $10,000 bond
It's low. Anything else?
Nothing further, Your Honor.
Didn't think so. Bond denied, most of the bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Cassandra Gray.
I'm busy probably handling her case, so. Your Honor, Assistant Public Defender Jay Bellinger on behalf of Ms. Bohr. Ms. Bohr, can you please state your name for the record?
Cassandra Bohr.
Court has before it a plea form. Is that what we're doing?
Yes, Your Honor, I have an advice right before me.
All right. Plea form indicates that the defendant would be pleading to an added count 3 of operating while intoxicated second offense, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's our understanding as well, Your Honor.
That the people's understanding? May I have the defendant sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Cassandra Bohr.
All right, ma'am, it is the court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. Is that correct?
Yes, Your Honor.
All right, that is a misdemeanor, punishable by up to 1 year incarceration, a $500 to $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You understand that the court could also order community service, any rehabilitative services support deemed necessary, could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You
Yes, Your
understand?
Honor.
All right. Now, understanding all of that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today to get you the plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
May 27, 2022, at the location of US 12 and Ecorse Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consumed intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had drank beer during the day, ate, and then I went to a bar and I had liquor, a couple drinks at the bar. I hadn't drove it all that day other than returning home that night when I got pulled over.
And Your Honor,
Were you stopped by the police or was there an accident?
I actually hit a ditch with my boyfriend's car and yeah,
So there was
police were
an
called to the
accident.
scene. I couldn't get
You
out.
didn't do that on purpose, did you?
No, Your Honor.
So there was an accident? Not with
Yes, Your Honor.
beer. All right. Did the police arrive?
Yes.
All right. Were you ultimately arrested?
No, Your Honor. I was taken to the hospital for a blood withdrawal. And then I talked to
But,
myself.
but you were taken there in a police car,
Well, yes, Your Honor.
right?
Yes,
So you were arrested.
yes,
You weren't free to leave at that point, correct?
correct.
All right. There was a blood draw.
Yes.
All right. What were the results of that blood draw?
Your Honor, we would stipulate to .277.
277? Ma'am, do you have any reason to dispute those blood test results?
No, Your Honor.
Had you previously been convicted of operating while impaired on or about April 18, 2013 in the 18th District Court and or operating while impaired on or about June 30th, 2014 in the 34th District Court out of Romulus?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3, counts 1 and 2 are dismissed. Pre-sentence investigation and report and screening assessment is ordered at 14B District Court. Sentencing in this matter will be
July 3rd, and with Judge Washington.
July 3rd, 2025, 10 a.m. before Judge Washington. Bond with its conditions will continue. Thank you.
We're all set, okay?
Court calls the case of the people versus Tania Jackson.
That's Lonnie for the people.
Here on behalf of Mr. Jackson, I don't know if Mr. Jackson is joining us.
Who do you have?
He's pulling on Jackson right now.
Okay,
He's pulling Jackson right now.
okay, thank you.
Good morning, Your Honor.
Their appearance.
Yes, Your Honor. That's Lonnie for the people.
Hugo J. McEnroe, appearing on behalf of Mr. Jackson.
Your name, ma'am?
Tania Jackson.
All right, what are we doing?
Your Honor, I've had a brief conversation with the prosecutor. I would ask that you allow both of us to approach the bench or something that I need to inform the court of.
Approach.
Thank you, Your Honor. We would usually request, myself and the prosecutor, that we.
I need a green sheet prepared. I'll adjourn probable cause to May 22nd,
Yes.
2025, 9 a.m. Bond continued.
I can put that we requested, it doesn't matter.
Court calls the case, people versus Michael Brooks.
Okay.
Public Defender Jay Bellinger on behalf of Mr. Brooks.
Michael Brooks? Need to unmute and state your name, please.
Can you hear me now?
I can hear you now. State your name.
My name is Mr. Michael Brooks.
Thank you.
Your Honor, we are just requesting a step for examination at this time. All discovery is complete to the best of my knowledge.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge That's before Judge Washington.
Thank you, Your Honor.
Bond will continue. Court calls the case, People versus Kyle Burmeister.
And then on behalf of the people, Your Honor,
Assistant Public Defender Jay Ballinger on behalf of Mr. Burmeister in case ending in 5078, Your Honor.
James Gladfelski appearing on behalf of Mr. Burmeister on the case ending 5028.
Burmeister, can you please state your name for the record? And Your Honor, we're just requesting a 3-week adjournment for purposes of him going in inpatient. He's just awaiting a bed right now.
That is correct, Your Honor.
Probable cause conference, June 5th, excuse me. 2025, 9 a.m. Bond will continue.
All right.
Thank you, Your Honor.
Court does call the case of the People versus Winona Harvey.
Morning, Your Honor. Hannah Back, requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Brian Bowling.
Permission to practice is granted. Good morning.
Thank you, Your Honor.
All right. Ms. Harvey, can you state your name?
No, I can't. I know, you got, my last name is Michelle. Where are you? Where are you?
I met with you in jail yesterday.
Look, if it's gonna skip, okay, yeah, okay.
All right. You're Miss Harvey?
Yeah.
Okay. You're seeking an adjournment?
I am, Your Honor.
No, not you. I'm not Miss Harvey. People don't miss Harvey. I'm Harvey. I'm Harvey like that. People don't miss me, but I'm Harvey.
Okay, so maybe she doesn't want to be addressed as a Mrs.
Understood.
No, I don't miss. People don't miss me or nothing. I'm Harvey.
Sorry about that.
My apologies.
Okay.
Probable cause conference will be adjourned June 5th, 2025. 9 a.m. Bond continue.
We'll be in touch, Harvey, okay?
When?
I'll come to
Excuse me,
you.
what's going on?
We just adjourned your case. Winona, remember we spoke yesterday and you said.
Until when?
Which date did you get?
June 5th.
June
Sorry.
5th, want to see me?
No, I'm gonna see you before then.
Look, I'm not going back. I can't go back to the conference room. That hurt my back a lot. That room you took me and hurt my back a lot.
Okay. I'm gonna let you talk to your attorney some other place, okay?
Okay,
Thank you. Shut her, please. Clerk calls the case, People versus John Fulton.
Deputy Chief Public Defender being on behalf of Mr. Fulton, he's in the lockup, should be on his way out. Your Honor, today's the date and time set for the probable cause conference. I believe that we've adjourned this matter because we're waiting for a mitigation report. That mitigation report is almost complete, so we'd ask for one more adjournment without the final piece of information we need.
Probable cause conference, May 29th, 2025, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Thank you. Gotcha. Court calls case, People versus Demond Branford.
Brian Bowling on behalf of Mr. Bransford.
Your name, sir?
Demond Bransford.
Thank you.
I have a green sheet, Judge.
All right. Requesting an adjournment.
I am, Judge.
Will be adjourned to May 29th, 2025, 9 a.m. Bond continue.
Your Honor, may I address one issue of bond? Would the court allow an order for him to be released to treatment if it becomes available?
If I get that order, I will sign off.
I will submit it. Thank you, Judge.
Thank you. Court calls the case, People versus Alan Franklin.
And then on behalf of the people, Your Honor.
Good enough.
There he is.
Morning, Honor. May it please the Honorable Court, David Burns on behalf of Alan Franklin.
Your name, sir?
Alan Franklin Jr.
Thank you. All right, what are we doing?
Your Honor, I was going to ask for an adjournment. I was just received this case Tuesday. I do not have discovery yet. I know I can't fill out a green sheet from Zoom, but I apologize, but just 2 weeks, Judge.
Turn this out May 29th, 2025, 9 a.m. or if your invite indicates, bond will continue. All right,
Thank you, Your Honor.
I'm sorry, I still will wear this tether or the
Pardon?
GPS. I still wear the
You
GPS.
still have to have the GPS on.
Okay, that's all I need to know. Thank you.
Okay, thank you. Court calls the case of the People versus Rick Artuso. Artuso?
And good morning, Your Honor. Assistant Public Defender Timothy Carey, on behalf of Mr. Artuso, who is approaching. Mr. Artuso, state your name for the record, please.
Rick Artuso?
Thank you.
Your Honor, I do have a green sheet. We're asking for an adjournment. We're currently in negotiations with the people. I would like to also address bond, please.
Matter will be adjourned May 29, 2025. Any, yes.
Your Honor, in regards to bond, we're asking, Mr. Artuso, well, Mr. Burgess is on one of his matters. I apologize.
Okay, good morning, Your Honor. May it please Honorable Clerk David Burgess, on behalf of Rick Artuso, as the other matter. All right.
So, Your Honor, in my matter, Mr. Artuso has $1,000 10% bond that was set. He does have a cash or surety bond in Mr. Burgess's matter. Mr. Artuso, it seems as if he went into bench warrant status on Mr. Burgess's matter because he failed to appear to court. He did indicate that he came to court on that date, but he was under the impression his court date was set for 2:00. When he did come, he stated he was here until the building closed and he left. Unfortunately, at that time, our office was not on his case, so he didn't call us. I'm unaware of his communications or if he was able to communicate with Mr. Burgess. So there was no opportunity to have a bench warrant recall.
So how do you come back into custody?
You said you were just in the car that was pulled over.
Yes, I got pulled over. But
So he was arrested on the bench warrant, Your Honor. There are no new charges. Mike,
So why didn't he come back to court?
I did ask him that as well.
Okay, and what was the answer?
He did not have an explanation, Your Honor.
Okay.
It was
Go ahead, I'm listening.
he did not have an explanation as to why he did not come back to the court, why he did not, contact the court to let them know that he tried to come. I did explain to him in the future if he's got any issues with his court dates, that the clerk's office is right there at the front, that all he needs to do is speak with them and they'll advise him properly. The issue that we're having is in our case, the resolution that we're seeking to reach would require that he pay some restitution up front. Unfortunately, with him being in custody, Judge, he will not be able to do that. He is hopeful that the court would consider giving him a PR bond. I understand if a GPS tether is necessary to ensure his return to court. He has very minimal criminal history, to my understanding as well, but I'd like to see if he could get out so he could raise some money and pay off this restitution so we could get a resolution.
Sponsoring people.
I would leave it up to your discussion.
If he doesn't appear, doesn't come back, it's got to be picked up. It's going to sit until we can get it resolved. Motion for bond reduction tonight. Bond will continue.
Understood, Your Honor. What do you need to say?
I was gonna ask you, Your Honor, worst comes to worst, I know I could, it's Thursday, I'm scheduled to be married on Sunday, I could come in Monday and I could pay restitution, whatever it takes to pay.
Scheduled to be what?
Married this Sunday.
That is true, Your Honor. He did inform us of that. I don't know if his fiance and his mother are here, but prior to his being picked up, I think he was scheduled to be getting married this Sunday.
I'm not going to use that as a basis to. I mean, the problem is that you should have come back down to the court. If you waited here all day, you should have come to the court at some point, but we had to pick you up, bring you in. I'm not doing that again. Thank you.
Thank you, Your Honor.
Why? Why? I guess. Sometimes yeah, stop. All right, never mind. Court is on the case of me versus James Clark.
Good morning, Your Honor. Audra Saber requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Janazai Kiri Akinruli, representing client Kyle Clark, who is present in person today.
Is that going to release the one that's supervising you?
That's correct, Your Honor.
How's that going?
It's going very well.
Is it?
Yes.
You don't know a whole lot, so you don't know, right? Never mind. Permission to practice it.
Thank you, Your Honor. Mr. Clark, please state your first and last name for the record.
Chen Clerk. Thank you, sir. All right, what are we doing?
Your Honor, we respectfully request that this matter be set for a preliminary examination.
All right, all discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That will be before Judge Fresh Hour. Bond will continue. Thank you, Mr. Clark.
Thank you, Your Honor.
The intern that just appeared, could you just get your last name over to my staff? Appreciate it. Court does call the case of the people of the state of Michigan versus Jeffrey Murphy. Ray,
Good morning, Your Honor. May I please have
And,
record David Burgess on behalf of Mr. Murphy.
Marie Tanha, AKA the phone.
Again, Your Honor, I apologize. Someone dared call my work cell.
What? Somebody called your work cell? I think it was somebody over there. They just, all right. Okay, what are we doing? Your name, sir?
Jeff Murphy.
Thank you. What are we doing?
Your Honor, discovery is complete in this matter, requesting exam be held.
People have their witnesses available the 27th?
I may have a moment.
Yes.
Your Honor, I do want to bring up something else that's concerning this case, and at this point, I'm hoping that the court can warn the defendant. I'm sure Mr. Burgess will speak to him as well. Part of this case is defendant posting naked pictures of the victim. Not that they should be anywhere, but certainly places that have put her at risk. They have since been taken down, is my understanding. So if the court wouldn't mind issuing a warning to the defendant about ensuring that does not happen again. And I believe Mr. Burgess is well aware of what I would do if this happens again, so he can have a conversation with his client about.
All right, so these came up after the charges in this case?
Let me double check. Your Honor, we don't know the exact date. I have to look into that.
Okay, but they have since been taken down.
Yes, it's been taken down, which is why I'm asking for a warning as opposed to.
All right. You understand that, sir?
Yeah, yes.
All right. And Mr. Burgess, you're gonna have a more detailed conversation with him about that?
Yeah, yes, I will, Your Honor. I'm well aware of what Ms. Tanner will do if that's the case. If he does it again, if it happens again, if it did happen in the first place, Your Honor, so.
All right, very good. Okay. And with the people
That's a good date, Your Honor.
that will work,
Thank you, Your Honor.
preliminary examination in person, May 27th,
Have a good day.
2025, 9 a.m. That is before Judge Washington. Bond will continue. Thank you. Let's call the case of the people versus Frank Clark.
Okay, I'm sorry, Your Honor. I apologize. We can call that previous case. Apparently I wasn't clear,
Okay,
if you don't mind.
you weren't clear? Okay, I guess, can we get him back?
I appreciate your defendant if it feels appropriate.
Well, hold on a second, because I lost Mr. Burgess.
I can call you.
Okay, so when he appeared, we'll get him back out at some point.
I'm in the
Can I have-
court. I'm in the court. I'm in the court.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender for Mr. Clark, who's in the court.
Yeah. Thank you, Mr. Clark.
Your Honor, I'd ask the court for a brief adjournment in this matter. We're still talking with the prosecutor in hopes of a resolution.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond continue.
Thank you. I'll give you a call, Mr. Clark.
Thank you, Ms.
Court call today's people versus Scott Jenks.
Yeah, then on behalf of Your Honor, Stephanie Can on behalf of Mr. Jinx. I did it. That's not him.
What's up with Cannon's clients?
It's Thursday, Your Honor, so the good news is I do have a plea in this matter, which I can hand to the court and the plea form.
Who do they have?
They were bringing back the other gentleman.
This Jenks?
Stephanie Cannon on behalf of Mr. Jinx. Station.
Scott P. Jenks.
I have before me a plea form that indicates that the defendant will be pleading to count 3, the domestic violence, with sentencing under 4A. That's the stated count 3. And defendant will seek alcohol treatment. He will also be pleading to an added count 4 of attempted resisting and obstructing a police officer to a 1-year offense. Upon his successful plea to those 2 charges, counts 1 and 2 would be dismissed. That's the court's full understanding.
That's right, Your Honor.
Your Honor, that is my complete full understanding of the agreement.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Scott P. Jenks.
All right, sir, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Yes.
Speak up for the court.
Yes, sir.
The first charge is that of domestic violence. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
The second charge is that of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty
Yes, sir.
to the charge of domestic violence? How do you plead?
Yes, sir.
To the charge of attempted resisting and obstructing an officer? How do you plead?
Yes, sir.
How do you
You gotta
plead?
say guilty.
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Can you hear him?
I have a hard time.
You're okay. We can get some equipment, so let's do that.
A little bit lower. Okay.
All right. Is that better, sir?
Yes, sir.
Okay. So up until that point, you heard everything else that I said.
Yes, sir.
Is that correct? All right. So you understand that by pleading, well, I think I was at the plea, so let's just make sure we have that. To the charge of domestic violence, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. You'll see a copy on the podium. I'll let you get your glasses. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you're guilty of these offenses?
Yes, sir.
April 20th, 2025, at the location of 418 North Point Drive, Northfield Township, Washtenaw County, State of Michigan. What did you do involving a Betty Jane Jinx that makes you think that you're guilty?
We got in an argument based off of a family member on her side that was making racial,
Your Honor, may I have water?
excuse me?
Yeah.
Go ahead.
You got in an argument with your wife
Yes, sir.
and you guys were married, living together?
Yes,
This was at the family home?
yes,
And during that argument, did you push her onto the couch?
yes, yes, ma'am.
Ultimately, the police were called?
Yes, ma'am.
And when the police were called, they attempted to arrest you and you pulled your hands back such that they had a hard time arresting you?
Yes, sir. Yes, ma'am.
Your Honor, do you believe that's a sufficient basis for the plea?
All right. You didn't have her permission to push her down on the couch when you did that, did you?
No, sir. She was pushing me. I was just trying to get her off of me. I didn't shove her real hard.
Oh, that kind of slingshotted around.
Yes. Yeah. So, but again, you were having an argument
Yes, ma'am.
and you did push her.
Yes,
You
ma'am.
didn't have permission to push her, true?
Yes. Yes, sir.
Yeah, okay, but, sir, you do realize that, I'm not saying it would be successful, but you may be able to assert self-defense in this matter? I don't want to hear your comment on that. You understand
Yes.
that is a possibility?
Yes, sir.
All right. Do you want an opportunity to discuss that with your attorney? Because as it stands right now, I cannot accept your plea.
Okay. Yes. Yes, sir.
Want some time to do that? All right.
Yes, sir.
So let's take him back and I'll bring it back out later.
Thank you, Your Honor. Give that to Mr. Allen.
And just remind us he needs the equipment when he comes back out.
Thank you, Your Honor.
Court calls the case, People versus Deshaun Clifton.
Stephanie Cannon on behalf of Mr. Clifton.
Your name, sir?
Deshaun Clifton.
Thank you. You're requesting an adjournment.
Yes, sir.
Probable cause conference, May 29, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
And I'll call you like.
Court calls the case, People versus Richard Johnson, the second.
Hannah Mackey on behalf of Mr. Johnson, who was to my right. Please state your name for the record.
How you doing today? Richard Johnson.
Thank you.
Your Honor, at this time, I believe we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available the 27th.
We can try our best, but I wanted to make sure the court was aware. Mr. Johnson has 2 other cases that are already set for exam next week. That's a short turnaround, so again, we'll try our best to get our witnesses there, but I didn't know if the court wanted to put them all together.
No, is there a reason they need to be all together?
There's no reason, Your Honor.
So he has 2 set next week?
Yes, Your Honor.
Preliminary examination in person will be. So will the people have their witnesses available the 27th on this case?
We'll try our best.
May 27th, 2025, 9 a.m. That is before Judge Freshour.
Thank you.
Bond in this matter will continue. Thank you. Calls case People versus Antoine Coleman.
Good morning, Your Honor. Student Attorney Andra Sabri on behalf of Mr. Coleman, who is present in person today. Say your name for the record, sir.
Antoine Coleman.
Your Honor, we are requesting an adjournment.
Why you tell, you know what to do? Why, just quit interfering until it's necessary. Just leave her alone. Thank you. I feel like you know something. How much time did you want, counsel? Don't look at her.
Your Honor, we are waiting for him to complete his assessment for drug treatment court, so however much time the court sees fit.
See, you did that all on your own. You didn't need, she wouldn't have told you that. She would have started picking numbers. Which court is he waiting on an assessment?
14B, Your Honor.
All right, let's do it this way. Thank you, counsel, for informing me of that. That makes it easy for me. Unlike your supervising attorney, but you. June 5th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor.
You're welcome, sir. Well, we wait a minute, because I don't. Oh, Dennis, okay, so let me get this guy, and then we'll get him back out. Hold on a second. I got these, this one? Or no, okay, all right. You just tell me, I'll deal with it. Court calls the case People versus Danielle Klimola.
Andrew Joe is on behalf of people.
And Assistant Public Defender, really on behalf of Danielle Klimola, who's approaching. Danielle, state your name for the record, please.
Danielle Klimola.
Thank you.
Your Honor, I am handing the court a plea form as well as the advice.
Here we go, get these before. But never mind. Court has before the plea form that indicates that the defendant will be pleading guilty to the charge of use of cocaine. That's a misdemeanor, 1 year misdemeanor of use of cocaine. Upon her successful plea to that charge, count 1 would be dismissed. There is the further indication that the defendant is to enter the 15th District Court sobriety court.
All right, I don't know if this, bring this up. My understanding is the defendant is under sentence on a year in jail. And there may be an ask.
That is
for modifying that sentence.
Today?
Whenever the court, I don't know how the court would like for us to address it, we
I
can
wouldn't,
come.
but go ahead.
We can submit a motion to that effect.
You have to present a motion.
Absolutely.
For that.
And I guess I'll put on the record right now, you have no objection to that and would be fine with the defendant's entry into a sobriety court program. She's been screened.
All right. Okay, this is the court's full understanding of the agreement. Is that correct? From British?
That is our understanding as well. Yes, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to the testimony you must give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Danielle Klimola.
All right. Now, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
I do.
Understanding, and I also should advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in 15th District Court. You understand that?
Yes, I do.
Still wish to plead guilty?
I do.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form. Is that correct?
Yes, I did.
Any question regarding those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
Yes. Yes,
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're indeed guilty?
Yes.
March 18, 2025, the location on South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
I did, yes.
Had you used it?
Yes,
Did you know what you were using was cocaine?
I did.
Counsel, have I complied with the court?
And to satisfy as well, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
Thank you.
Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
June 3rd at 10 a.m. with Judge Allen.
June 3rd, 2025, 10 a.m. Judge Valvo.
This was also an email from Ms. Johns from the 15th District Court about possibly setting this on Friday. I don't know what this was, those sentencing dates for 15th on Fridays. I'm sure they could also modify it. Judge Valvo could also set it on a different day. I know the court only gets so many days.
Yeah, I don't have that.
I only have June third.
So we'll just set it that.
Yeah, okay, I'll just send it to
And
you.
you're on with that at 9 a.m.
Oh, it's at 9 a.m. before Judge Probable. All right, okay. Thank you.
Thank you so much, Your Honor.
Court does call the case People versus Elijah Kraft.
Haley's in on behalf of the people, Your Honor.
She's back.
Good morning, Your Honor.
They gave
Student,
you a bunch of cases, didn't they?
yes,
Did they?
not a bunch, a fair amount.
Not a bunch? Who gave them to you? Did she give them to you?
I cannot confirm or deny, but I was assigned. I'm kidding.
Did Akin really give you all these cases? Did she say, when she gave them to you, I don't want to do anything today?
No.
Oh, she didn't say that? Okay, I was just checking. All right, go ahead, counsel.
Student attorney Andra Sabri on behalf of Mr. Elijah Kraft, who is present in person with me today, Your Honor. If you could please state your name for the record.
Elijah Kraft. Thank you, sir.
Your Honor, we respectfully request that these matters be set for a preliminary examination.
All right. And on both of these matters, all your discovery is complete?
To my knowledge.
And would the people have their witnesses available the 27th?
We'll do our best, Your Honor.
Preliminary examination, May 27th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Right. Bond will continue. Thank you, sir. Court calls the cases of the people versus Dale Miller, 3 cases.
And Maggie on behalf of Mr. Miller, who is approaching. Please state your name for the record.
Dale Miller.
Your Honor, we recently have received a competency report and we stipulate to findings of Mr. Miller being incompetent but restorable.
They determined that he's incompetent to stand trial at this time, but likely to obtain competency through treatment. Is that correct?
Yes, Your Honor.
All right. All right, I have reviewed that report. I will sign off on those orders. I'll set a competency review hearing. I need 90.
90 days would be August 14th.
August 14, 2025, 9 a.m. Defendant's bond will continue.
Right. Thank you, Your Honor.
Thank you. Court does call the case of the people versus Martez Dalton.
Anna Mackey on behalf of Mr. Dalton, who is, I believe he's riding a bus right now at the court, Your Honor. The last we've heard, he was in downtown Ann Arbor 20 minutes ago. It's a slow bus.
He came from Detroit. Let him know he came from Detroit.
The bus has been driving from Detroit, Your Honor. Maybe it ran out of gas.
What?
He's coming. The bus is coming.
How do I know he's on a bus?
I spoke to him, Your Honor.
Huh?
I spoke to him and he said he was on the bus.
So what do you want me to do? Bench warn him?
No, Your
And
Honor.
we can go get him?
If you could please pass this matter for a few.
A few. Okay, so hold on. I went through this almost exact same thing with Cannon. And yes, I know, they had pictures all along of him on his bus ride. It was
So
like
it's a
trees.
common
It was
thing.
video. It was just trees going by a window on a bus. I don't know if it was on a bus. But if they say had gave me pictures, not you, nothing.
I'll provide photos, Your Honor, in a minute. It's clearly a common problem with buses. If Stephanie had the same issue with her.
Okay, Mackie, when's the last time you got on a bus?
For school, Your Honor. We ride a bus from the parking lot to class. It's like a mile walk.
When's the last time you got on a bus for travel around the city or?
New York. Subway, that's even better. Subway.
A subway is different than a bus.
Okay, I've never been on a bus, Your Honor.
I didn't think so. Okay, thank you. I'll pass it.
Thank you, Your Honor.
Never been on a bus. I know. I don't know why you're trying to fight it. Just say I've never been on a bus. She doesn't even know if it's a slow bus. Court does call the case. People versus Rahman Mohammed.
My client is not on the bus.
Are you calling him, Mackie?
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Rahman Mohammed. Mr. Mohammed, please state your name.
Rahman Mohammed. Thank you.
Your Honor, today's date and time set for probable cause conference. We are respectfully requesting that this matter be set for preliminary examination. Also, we'd like to address bond at the.
All right, all discovery is complete.
As far as we know, Your
People have their witnesses available the 27th.
I didn't want to let council know Mr. Muhammad has a new warrant in, as of just a few days ago. I was received for a heightened jail apparently, so I have that with you.
Preliminary examination, May 27th, 2025.
Thank you,
9
Your Honor.
a.m. That's before Judge Fresh Hour.
Thank you, Your Honor. As to bond.
Yes.
Your Honor, my client is respectfully requesting that the court allow him a personal recognizance bond. He does have a place to stay. He would stay with his father, Kushir Muhammad. That would be in Anna Street in Detroit, Michigan. He's asking if the court feels that it's necessary, he would agree to wear a tether to ensure that he returns to court.
Response.
Your Honor, I think the underlying case, or the case that was set for exam is a bit older, if I'm not mistaken. I'm not sure how many in custody. I'm concerned that while he's in custody, potentially accumulating assaults and offenses, but I'll leave that in discretion of the court. I would request that if he is released, that he is testing, given the nature of this.
My client will agree to test.
How did he come into custody? A traffic stop.
Your Honor, my client tells me that it was a traffic stop.
Oh, Your Honor, maybe approach, please, very quickly.
Approach. Record should reflect, we've had a bench conference in this case. And in considering everything, I'm going to deny the request for change in bond. Bond will continue.
Thank you, Your Honor.
Thank you. I'm trying to get the court calls case People versus Aaron Daniels.
And then on behalf of the people, Your Honor.
And I'm Mackie on behalf of Mr. Daniels, who is to my right. Please say your name for the record. At this time, we'd like to request that this matter for preliminary examination and all discoveries complete as far as we are aware.
People have their witnesses available the 27th. Preliminary examination in person will be set for May 27th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court calls case of the People versus Danielle Pressey.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Pressey, who's approaching Judge. Get your name?
Danielle Pressey?
Requesting an adjournment.
Yes, Your Honor, there's a lot of discovery to go through.
May 29, 2025, 9 a.m. Bond continue.
If I could be heard on bond, Judge?
You may.
Thank you. Judge, I did have a chance to talk with Ms. Pressey. She is here before the court with a bond of, I think it's set at 150,000 cash. This is a situation where she has absolutely no criminal history the last 13 years or so. She does have an old OWI matter from 2012. That's all I could find on her CCH. She resides in the Metro Detroit area in Oxford or Lapeer. She owns a business, a brick and mortar business, a nail salon. She's not a flight risk in any way. She cares for her disabled mother. She is, like I said, gainfully employed. She owns a business, a nail salon that she is the proprietor of. We'd ask the court to consider some kind of a reduction in bond, hopefully a personal bond, like if she would avail herself of any both a scram and a GPS tether if the court thought that was beneficial to ensure both her presence and that she's not anywhere that she should not be. She has, as I said, work, family responsibilities, and have to care for disabled mother.
Response.
The facts of this case involve a defendant traveling around 60 miles an hour. It's on Marks Road, which I believe is 45, but it's probably 45 would be my guess. 60 miles an hour with now candidly the BAC was 0.038, but there was also 200 nanograms per milliliter of amphetamine, as well as THC, 2.7 nanograms of THC in her system. The victim is tragically the defendant's son, I believe 7 at the time. He was improperly belted in the rear seat and killed in the accident. The vehicle crashed into a tree. Based on those facts and circumstances, I don't believe that the bond is improperly set. I believe that the facts of this case are awfully tragic, but I am concerned about defendant's potential conduct fall out, this matter pending if it's serious.
Your Honor, if I might, this is a very serious situation, very tragic. There was, the allegations of the purported Adderall, I believe, was a prescribed drug. As Mr. Childers stated, there was a 0.038 of what was the reported drug or alcohol. This was, like I said, this was a situation where I don't think she comported herself. This accident happened several months ago. She's comported back in December, I believe. She's comported herself properly since then. She'll continue to do so. As I said, she's not a flight risk in any way. And she does have responsibilities while we, there's a lot of information to look at here. And I believe this is a matter that is going to be litigated pretty heavily. So I'd ask the court to reduce the bond.
Motion for bond reduction is denied. The court does consider the defendant a risk to public safety. And so her bond will continue. Thank you.
Thank you. Your Honor, if we did put together a written motion, would the people waive notice on that?
I'll wait notice as long as you don't give it to me at the end of the day on Wednesday.
No, I don't do that. Okay.
As long as I have a fair amount of time to respond.
Court consider hearing it early as well, Judge?
It will, when we receive the motion, this Whiting will be more than happy to give you a date to hear.
Thank you, Judge.
Court does call case of the people versus Jordan Davis.
I'm sorry, Judge. I didn't catch the adjourn date. My fault.
29.
Thank you.
All right. Jordan Davis.
And then on behalf of people, and Mackie on behalf of Mr. Davis, who's approaching. Please state your name for the record.
Jordan Davis.
Okay. Your Honor, at this time,
No, I'll wait.
we'd like to set this matter for a preliminary examination.
All discovery is complete.
As far as we're aware.
People have their witnesses available to 27.
Yes, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Fresh Hour.
Thank you, Your Honor.
Thank you.
Bond will continue. Thank you. Court recalls case, People versus Jeffrey Murphy.
Right now, that's just the prosecuting attorney about people.
Good morning, Your Honor. Again, may it please the Honorable Court, David Burgess on behalf of Jeffrey Murphy.
All righty. Thank you for coming back, Mr. Burgess.
Yeah, of course,
Yes.
Your Honor.
Thank you, Your Honor, for recalling the case, and thank you, Mr. Burgess, for jumping back on. Mainly, I want to make sure the defendant's not confused about how this process is going to work and what his bond conditions are. The victim was present here today in the gallery, and defendant decided it was a good idea to mean mug her as he walked by her. Here.
Sir.
Now, I know that this defendant has a history of abusing women sexually and physically, and apparently somewhere along the way, he has learned and decided that intimidating a victim of his crime is a good idea. Like I said, I think he's confused, so if we can clear some of that confusion, I would appreciate it.
All right. So you understand that? That
Yes.
you're not, and when the court is saying no contact, no intimidating or threatening behavior, that applies both here in this courtroom and all of your behavior. You understand that, sir?
Yes.
And so if the alleged victim is present in the courtroom, I don't want you staring at them any kind of way.
I got you. I apologize.
All right? All right. Thank you. Thank you, Mr.
Yes, of course, Your Honor.
Court calls the case, People versus Harold Dennis.
Assistant Public Defender Jay Bellinger on behalf of Mr. Dennis. Mr. Dennis, can you please state your name for the record? Harold L. Dennis.
All right, I have before me a plea form that indicates that the defendant would be pleading guilty to an added count 2 of larceny, less than $200 to 93 the offense. Upon his successful plea to that charge, count 1 would be dismissed. There is no objection to sentencing under 77(1.1).
That is our understanding of the plea, Your Honor.
I have him sworn.
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? You got it.
I do.
State your name.
Harold L. Dennis.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny less than $200. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $500, that would become the maximum fine. You understand all of that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Okay.
You understand that?
Yes.
You wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Okay.
You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you are indeed guilty of this offense?
Yes.
On date of August 19, 2023, at the location of 1150 Nash Avenue, Ypsilanti Township, Washington County, State of Michigan, what'd you do regarding property belonging to Willie Rawls and Willie Rawls Jr. that makes you think that you're guilty?
Well, actually, I didn't do anything that,
Did you have an agreement with him?
yes,
And did you take his car as part of that agreement?
yes,
And as part of that agreement, you were to return that car within a specific amount of time?
yes,
And how long did you keep the car?
too long,
And how long is too long?
a couple years.
Okay.
2 years?
Yes.
Is that what you said?
Yes.
I'm just,
And was the value of that property under $200?
well, it doesn't matter.
I understand for the purposes
But-
of your honor.
So how long were you supposed to have the vehicle?
Well, there wasn't a determined time, but supposedly till I finished,
Tell you what?
till I finished the job.
What job?
You were doing work
I
on the
was
car.
doing work on the car.
Oh, you were doing work on the car.
I'm,
And so then after you did the work on the car, you were supposed to return the car.
well, I was not finished with the work on the car.
2 years later?
Well, yes, 2 years later. And
Did the owner of that vehicle have an expectation that you would turn that within a sufficient amount of time?
yes,
And did he contact the police as a result of you not returning the vehicle?
yes,
If I could briefly, were there multiple requests for the vehicle to be returned
Thank you.
that were not responded to?
yes,
So that we're really clear, the work that you were supposed to do would not take 2 years to complete,
No.
would it?
no,
In fact, it should have been completed well before that 2 year period,
yes,
correct?
yes.
You just didn't do the work.
No, actually, I did do the work.
He did some
Okay.
work,
Well, I didn't have it finished,
and the
but,
vehicle was returned after the adjournment of the PCs.
and it was returned fully finished and in excellent shape,
But 2 years old.
which I was trying to do in the beginning.
Well, here's what I do. Yeah, there certainly would be a higher charge I could accept a plea to, given the facts of this case. So with that understanding, counsel, have I complied with the court rule? Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B District Court sentencing
July 3rd at 10 a.m. for Judge Washington.
July 3rd, 2025, 10 a.m.
10 a.m.
10 a.m. before Judge Washington.
Okay.
Bond will continue.
You need to contact 14B probation as soon as possible. And that's your sentencing date. Okay, and fine. And that's the location.
Where am I saying?
You don't need to sign off on this one. That's just for you to keep for your record so that you know when to go to that court, okay? You can give me a call later. All right, take care of you.
Just thinking. Court calls case People versus Barrage Scott. Bellinger, don't come up here with anything else like that.
Andrew Childers, on behalf of people.
We're ready in this matter, Your Honor. Lon Brown, Deputy Chief Public Defender, being living on behalf of Barrage Scott. Barrage, state your name. Barrage Scott.
How you doing?
How you doing, sir?
I'm okay.
You're doing very well, Your Honor. Your Honor, today is the date and time set for a competency review hearing. I do not believe that the report has been completed at this time. Does the court have?
I do not have a report.
So, Your Honor, we'd ask for an adjournment to see if that report can be.
Let's do this. Has he been interviewed at all yet? Has he come talk to you, Mr. Scott?
From the forensic center, I'm confused.
Yeah.
Yeah, I went to the forensic center. and
Okay.
did a evaluation or something.
Yeah.
They took me from the jail.
Jail to
And
the,
then, yeah,
okay. So when did that happen?
like maybe a week or two.
Oh, just about a week.
Yes,
ago.
sir.
Okay, all right. So let's do this. Let's put you out. Still got to get a report, so. I'll put you out. Let's set this hearing date. I'm indicating no report yet, but we'll set it for June 26th, 2025.
So they're gonna be able to do anything.
Okay, that's fine. I understand.
How you feel?
Yeah, but I'll set, which ones? They're both gonna be,
Yeah.
No, she already had it. She passed. April something.
Okay, so we don't.
I'll just adjourn your probable cause to that same date, 26th. I can't go ahead on that case anyway. Whether there's, I technically don't have a comp referral on the other matter, Mr. Brown. I don't have a comp referral on the larceny of building case.
Oh, you
I
got it.
do on the armed robbery case, but I can't do anything on that case with that other one pending anyway. But
Right,
just
right.
so you
So,
know.
okay, we can do an order to match that one. Your Honor, what is my client's bond on this case?
On which case? On the larceny case, his bond is set at 1,000 cash or 10%. On the armed robbery case, his bond. Yeah, but what do you have his bond on there? I think it's denied.
You know, we would ask that the court do set a bond in this case. He does have very strong family support, as he has always had. Yes. They are pressing. We're asking that some bond be set for him.
Well, I think his bond got revoked on a, he was on bond on another case when this happened. So I'm not sure if he'd be entitled to have a bond in any respect because I released him and 8 days later, this case happened.
Okay.
So I'm going to decline to change his bond at this time. Let's get the report back and see where he is.
Report back.
The bond on these matters will continue.
Oh, yeah. Absolutely.
All right. Thank you, Mr. Scott. No. Court calls case People versus John Fleming.
Good morning, Your Honor. Student Attorney
Okay.
Audra Sabri on behalf of Mr. John Fleming, who is present with me in court today. Record, sir.
John Fleming.
Where are the rest of his payments?
Oh, hoping I'm going to work after this.
Your Honor, we
You'll
are,
talk to him about that afterwards.
will do, Your Honor.
Thank you.
You got workload today, don't you?
Your Honor, we are requesting an adjournment.
Your Honor, we need a protective order in this case. There's a forensic interview with the child victim. That I want.
Okay. Is
I have received the protective order, Your Honor. I was just going over it. I'll submit it to the court.
Court. All right. So probable cause conference will adjourn to May 29, 2025, 9 a.m. On continue.
Thank you, Your Honor.
Thanks, sir.
Thank you. Calls case People versus Rashad Shafi.
Morning, Your Honor. We're Yagi, Assistant Public Defender, with and on behalf of Mr. Shafi. And I do apologize, Your Honor, but maybe approach on this one.
What would a day be without Yagi approaching? Come on. All right. You're requesting that these matters be set for exam.
That's correct, Your Honor.
Discovery is complete then on both cases.
To our knowledge, Your Honor, yes.
People have their witnesses available to 27. Preliminary examination in person, May 27th, 2025, 9 a.m. That is before judge. Court calls the case People versus Jamie Good.
That's a lot of the people. Good morning. Judge Simpson.
Emma Dadush on behalf of Miss Good.
I was wondering if they were going to let you have any case.
I had more.
Huh?
Kidding. I stipulated to adjourn a bunch of them.
See, even like Akinruli could have given you some of hers because she's not done anything. Go ahead.
Can you say your name for the record, please?
Jamie Good.
Thank you.
Your Honor, this is the first PCC on this matter. We are going to be asking for an adjournment to continue plea negotiations.
Do I have a green form?
Yes.
Probable cause conference will be May 29th, 2025. Continued. Thank you.
Thank you.
Thank you.
Let's call the case, People versus D'Angelo Simmons.
Good morning, I'm Mary Kenneth, Assistant Public Defender.
I read in that, Ron Brown, Deputy Chief Public Defender, appearing on behalf of Mr. D'Angelo Simmons, who approaches from the lockup. Under today's date and time set for a competency review hearing, does the court have an updated report?
My most updated report is from April 8th. Dated April 8th, received by us April 14th.
And have, okay.
Double checking, but I believe yes, that's the last one I have.
That's the last report. I don't know why this wasn't sent earlier. Or moved up once we got that report.
May I have my client state his name for the record?
Yes.
D'Angelo Simmons.
All right. Well, they would do a review from April 8th. That'll be about July something. So I'll just indicate at this point I don't have a report. I'll set it out basically at 90 days from the date of this report. So hopefully we'll have something. What's my closest date to July 8th?
July 17th.
All right. No, that's fine. That's a Thursday.
Yes.
I'll set that out to July 17th, 2025, 9 a.m. If we do get a report, this one should have been moved up itself, but if we do get a report, we'll move the date up. All right.
Thank you, Anna.
Thank you. Court does call the case, People versus Douglas Hill.
You gotta cover your butt. You don't want to see it.
Okay.
Thank you, Your Honor. I did provide the court with a clean sheet. We're simply asking for a brief adjournment in this case.
If I were to test your client, will you test clean today? And I don't like being lied to.
Probably not.
Okay.
What would be in your system?
I've been tested dirty for cocaine and THC, I believe.
3 successive occasions. Mr. Allen. I have a bond violation report here.
But I haven't even been out a week to get my system clean. I just caught this charge and the bond was just set, so I haven't had time to actually get my system clean.
I have a whole week of testing with cocaine in your system.
We also have a failure to appear for CCOP, is that correct?
For CCOP, what's that?
It's correction stuff.
No, oh, yes, they rescheduled my appointment for Monday at 9:30 with the Brown guy for the outpatient program.
Yeah.
Yes, because I thought I showed up at 2, it was at 1:30, and then I also dropped yesterday.
Why is cocaine still in your system?
It will not be today.
Well, you just told me it was gonna come back.
Because I haven't dropped clean yet, that's why I assumed that. I don't know how long it takes to leave.
You're still using.
No, I'm not.
No, because you want, okay, I'm gonna tell you what, if you're telling me you're not, I'm gonna take you back, I'll call over, get levels, and then we'll see exactly what's happening.
So I got.
You want me to do that?
So I can drop today?
No.
I'm sorry, I
You
didn't.
would go back there with my bailiff, I will call over and get levels. If you're telling me that your system is just cleaning out.
My system should be clean.
No, that's not what I'm saying. You're telling me you're not using,
Correct.
right?
Yes.
Okay. Then this must be some super duper cocaine.
I have.
So we'll figure it out. And so what I'm gonna do is, Mr. Allen, you can take him back. We will call over to community corrections, get your levels, and then we'll figure out what's happening. They probably don't have anybody right there then. They do? Okay. Court does call the case, People versus Romeo Serva. Oh, 2 in a row.
Kelvin Tadish on behalf of Mr. Serbo, who is approaching.
Your name, sir?
Romeo Serbo.
Thank you.
Your Honor, we are going to be asking for an adjournment for mitigation, and we would like to address bond, please.
Probable cause conference will be adjourned June. May 29th, 2025, 9 a.m. I need a green sheet and then that's bond.
As to bond, Your Honor, I wanted to address, I wanted to ask for him to be released on tether. Your Honor, Mr. Serbo is 20 years old. He has 2 children that he takes sole custody of. He has to take care of them right now. They're in the care of his father and his foster grandfather and foster grandmother who aren't able to actually keep taking care of his children. He has been in school. He has a 4.0 GPA. He just got his transcript back. He had a job interview. He's doing really well. The reason he was missing them is just because he had so many things going on. They were early in the morning. He has these 2 kids. I can assure you that if you put him on a tether, Your Honor, that you will be seeing obviously no missed tests, but no positives or anything like that. He is not drinking. He doesn't drink. He reacts very poorly to it. So we are going to be asking for that.
Yeah, but he wasn't testing on his SoberLink device. I mean, he just wasn't testing like he should.
Yeah, there's 2 that he missed. He was in custody for those. Those are the first 2 missed ones on the report from March. And then he had 4 missed ones, but he submitted a compliant test like within 15
No,
minutes.
I'm talking about, I got that, but his April 24th report from Community Corrections.
I'm not in receipt of that. The last one I have is as of April 23rd. I may have missed it, but
April.
The report that I have, the last test on there that was missed was the 23rd of April. Let me look.
Right, but there should be a bond violation report from April 20, that's dated April 24th, 2025.
Oh, this is the one. Oh, no, sorry. Yeah, April 24th. This is the same one that I'm looking at.
Okay.
Okay.
Go ahead.
Yes. As 2 of those were missed when he was in custody elsewhere. 4 of those he missed, but he retested like within 20 minutes, 15 minutes, 7 minutes after the 9 a.m. block. I believe there's only 2 that he missed that he never retested for, and those were the newly added time window. I believe he had either forgotten about those, and I understand that that's not an excuse. He just has a lot going on with school, with work, with his 2 kids, and that's why I believe having him on a tether would resolve this issue. He should have been put on tether from the beginning, honestly. But if Your Honor releases him on that tether, and he's not missing any of his drug tests. So.
Any response? Okay.
The only thing I'm concerned about was in September of 2023, the defendant was placed on probation in the Oakland County Circuit Court on 2 counts of RIO and an A&B or HIDA. And obviously this offense occurred in June of 2024. So it would have been while he's on court supervision, Oakland County Circuit Court on a similar charge that also falls with the defendant's ability to cover.
Your Honor, he is undergoing mitigation for mental health concerns that we're going to provide to prosecution. I've talked to his attorney in his Oakland County cases. He is on probation for those. He's testing in so many different places for so many different things. That's why also he is having trouble keeping track of these tests. And I mean, again, I believe a tether would help with all, huh? What do you want to say?
I just want to that I did ask when I realized it was going to be a problem. So I won't have any problems with it.
Yeah. He's saying that he requested, well, he wanted tether in the first place, and
When you're saying a tether, you're talking a scram tether?
Yes, sir. And if I was to get that, I wouldn't have any problems. You wouldn't hear it from me. I don't drink alcohol. There's no alcohol in my household. It's just 2 children and I go to school every day.
2 children and some pot, right?
Well, I smoke outside the house and it's never around them.
Okay. Do you have a card?
Yeah, I do. And
Did you give us your card?
I offered to give that to community corrections, but they refused to take it every time I offered it to them.
and his father submitted it. They'd already submitted it to community corrections. I don't know why community corrections lost track of it, but I talked to his father yesterday, and his father said that he sent community corrections a copy of it again yesterday, but that every time he goes to test, he has his medical marijuana card on him and it's active. And I can send that to the court right now.
Yes, I will modify his bond, although he may not be entitled to a $25,000 personal recognizance bond, but he needs to be on a scram tether prior to release.
Thank you, Your Honor.
And I've set this over to the 29th.
Thank you, Your Honor.
Thank you.
Thank you.
Case People versus Sherry Hughes.
Thank you, Richard, Deputy for the people.
Morning, Your Honor, Mike Gaddy, Assistant Public Defender on behalf of Ms. Hughes, who's not here. Judge, I did submit a green form. I did receive a call from Ms. Hughes' mom yesterday stating that she was at St. Joe's psych ER. I got a call around 8:30 saying that they're waiting to be discharged. And I don't think she's in a position to actually be still going to court today. I'd ask the court to excuse her presence and adjourn this matter.
Well, I'll need some documentation, but Mr. Gaddy, but I'll adjourn this over to the 22nd, 1 week out.
Thank you, Judge. I will.
2025, 9 a.m.
Thank you. I will provide the discharge paperwork when I get it. Thank you.
Court calls the case of the People versus, you said lot. It's LaDonta Skinner. I don't know why they have it this one.
Thank you, Richard, Deputy for the people.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Skinner, who approaches the podium. Skinner, please state your name for the record.
LaDonta Skinner.
Thank you. Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination.
Both matters.
Yes, please.
Discovery is complete. But
Yes, to the best of our knowledge, discovery is complete.
people have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That will be before judge. Continue.
Okay, Your Honor, what does the court show as the bonds in these matters?
1,000 cash surety on the case ending in 5724. And on the other matter, same thing. 10%.
Both are 10%, Your Honor.
Hmm?
Both are 10% allowed.
It is cash surety 10%.
Okay, all right. Thank you very much, Your Honor.
There you go. Somewhere. Courthouse case People versus Joel Stevens.
Jennifer Douglas for the people.
With that, on behalf of Mr. Joel Stevens, who is approaching.
Joel Stevens.
All right.
Your Honor, we are going to be setting this for a preliminary examination, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That's before Judge
Washington.
Washington. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Davian Thomas.
We're ready in that matter, Your Honor.
Andrew Childers, appearing on behalf of the people.
Lauren Brown, Deputy Chief Public Defender. They're appearing with and on behalf of Mr. Davion Thomas. Mr. Thomas, could you state your name for the record?
Davion Thomas.
We're doing the plea.
Yes, please.
The plea form indicates a defendant will be pleading guilty to an added count 3 of larceny by false pretenses, 200 to 1,000 to 1 year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed, and it is okay for him to seek hideout in the case. That's the agreement of the parties as the court understands it.
That is our understanding, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Davion Thomas, Your Honor.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny by false pretenses, $200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property. If it 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 court. Do you understand that?
Yes, Your Honor.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes,
Yes. And to that charge, how do you plead?
guilty, Your Honor.
You understand that by pleading, you does not have a trial?
Yes, Your Honor.
Did you sign an advice of rights form?
Yes, Your Honor.
All right.
Approach.
Yes. Signed an advice of rights form. You have any question regarding those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce
No, Your
you?
Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're indeed guilty of these offenses? On between the dates of January 22nd, 2024 and January 31st, 2024, at the location of Eastern Eateries on the EMU campus, Eastern Michigan, Washtenaw County, state of Michigan, what do you do that makes you think that you?
Yes, what did you do? No, we're talking.
I used cars without permission, Your Honor. So,
What kinds of cars?
I had used someone card without their permission.
To
So
get food?
to order a DoorDash, which was $40, and I was wrong, Your Honor.
All right, so you did that. And and in using these cards, the value of the property that you received, was that in excess of $200?
No, Your Honor. It was,
Your Honor, I'd be asking the court to take the plea.
To a higher charge for that. All right, and the court can do that. And you didn't have anybody's permission to be using these cards?
correct, Your Honor.
All right. All right. Counsel, have I complied with the court?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
May 28th, Judge Barr at 10 a.m.
May 28, 2025. What time? Time?
10 a.m.
10 a.m. before Judge Barr.
Your Honor, may I address the issue of bond?
Go ahead. Everybody else.
Your Honor, my client originally he was not incarcerated. The court put him on, I believe he missed a court date. I think he had taken a trip, a family trip. He had taken a family trip. He was able to do that, but he wasn't able to make it into the next court date. I believe that's how the case went.
Yes.
So as a result, the court put him in. We're asking that now that he's pled to the misdemeanor. This is a property offense. My client is scheduled to start classes on May 19th. We'd ask that his bond be reinstated. He be allowed to be released from incarceration at this time.
So is he gonna be at EMU?
Macomb Community College.
Okay, so how do I know that he's gonna get back here?
Oh, he'll make it back.
Huh?
He'll make it back. He has not enjoyed his time in the Washington County Jail.
Okay, so how did he come into custody?
I turned myself in, Your Honor.
You turned yourself in where? Here?
Yeah.
So he knows how to make it back here, Your Honor.
Any response from the people?
No, I would agree. I believe the defendant appeared in front of you back on May 1st and he was remanded.
Got it. That's what okay. So you know the importance of showing up now?
Yes, Your Honor.
You ever been in jail before?
No, Your Honor.
So this has been Mr. Brown's right. This has been an experience for you.
Yes, Your Honor.
Meaning you take it serious, right?
Absolutely, Your Honor.
I'll reduce the defendant's bond. I'll set it at $25,000 personal recognizance bond. And they get him back. Court does call the case of the people versus Brendan Williams.
In favor to the people?
We're ready to start, Your Honor.
Or Brown.
Deputy Chief Public Defender Ping, Ribbon on behalf of Mr. Williams.
Your name, sir?
Brendan Williams.
What are we doing?
Your Honor, we are respectfully requesting we're going to set this matter for preliminary examination.
Discovery complaint.
Yes, and well, there's a complication. There's a new case that's arisen. We'd like to be able to resolve these matters, but we have to know what's happening on the new case because that's going to be part of this. So it is complete for this case. We may even resolve this case short of preliminary examination, but we will need to have that other case.
The other case, does it affect this case?
Your Honor, if I can say a comment, I thought we were adjourned for that purpose, but Mr. Williams has a high BAC case set for arraignment. It is out of this court. And the arraignment date that was set for his summons is June 18th. So our request was going to be that the court, I don't understand the not for today, but if that file could be pulled so that he could have been arraigned on his next adjourned PCC date, but we don't have one. We're setting it for exam. I had discussed with Mr. Brown that we might be able to figure out something between those two. So if we're setting it for exam, we don't need to worry about the other case. We wouldn't have time to do that.
People have their witnesses available the 27th.
What's right?
Preliminary examination in person, May 27th, 2025. 9 a.m. before judge. Fresh hour. Bond will continue. Thank you.
And may we address the issue of my client is currently the bond set right now.
I have it at 10,000 cash surety.
And we're asking that the court consider in this case a personal recognizance bond with a tether. He does have strong family support. His aunt and his family have been in the court all day today awaiting for this matter. I've spoken with his aunt. She would be willing to allow him to stay with her during the pendency of this matter.
The case, the new high BAC, what was the offense date of that?
Right, the IBAC offense date is, I have it right here, that was April 3rd of 2025.
Okay, here's my problem. I've got that charge coming up, and I'm not presuming is his guilt on that. But I certainly got a high level of alcohol involved in that case. That case is coming up. I've got an indication that there's alcohol involved in this case, plus then assaultive behavior on, is at least alleged in this case. At this time, and maybe certainly after Judge Freshour hears it, her mind will change on this, but at this time, I'm not gonna reduce the defendant's bond. I'm gonna deny the request for modification of bond and bring out Hill. Oh, we have either one. Who do you have? Hill, do you have Jenks? Yeah. Okay, I'll bring him out. That's fine. Court recalls the case People versus Scott Jenks.
And then on behalf of the people, Your Honor.
And Stephanie Can on behalf of Mr. Jinks, who is appearing to my right. Mr. Jinks, please state your name for the record.
Scott B. Jenks.
Giving me his equipment.
Help me. Oh, I did.
Did you get it? Okay. Your Honor, I've spoken to my client regarding the possibility of a self-defense argument and his desire potentially go to trial. My client has indicated he does not want to go to trial. He is not exerting a self-defense and he would like to proceed with the plea.
All right. So you're waiving your right to assert a self-defense claim. Is that correct, sir?
Yes, sir.
All right. And so at some point during the altercation with your wife, you, without her permission, put your hands on her and pushed her down. Is that correct?
Yes, sir.
All right. Counsel, with that testimony, has the court complied with the court rule and would it be proper to accept this defendant's pleas?
Yes, sir.
You have, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
June 5th at 10 a.m. with Judge Freshour.
June 5th, 2025, 10 a.m. before Judge Fresh.
Your Honor, may I address bond?
You may.
Thank you. Your Honor, with this plea agreement and the felonies now being gone, I would ask my client be released on a PR bond. A part of this was treatment. He could be screened for any sort of treatment necessary. He has strong family support. His daughter is here. His daughter is here. The family home has been vacated. It's my understanding from her that the complaining witness in this case is now living with the daughter and no longer at the family home, so he can go home.
His daughter?
Yes,
Okay, so, okay, gotcha.
yes. That the complaining witness is no longer living at the family home, so he would have somewhere to go. This is his very first time doing, well, anything. My client will appear for court. He has no desire, nor will he be seeking any contact with the complaining witness in this case, Your Honor. We're asking for a PR bond.
We have not had direct confirmation from the victim that she has vacated that address. We don't have a new address that she has. However, I would leave it in the court's discretion as to release. If he was to be released, Your Honor, I would ask that he be placed on a GPS tether as well as some type of testing, or alcohol testing or a scram tether.
Do I have an indication of alcohol use in these cases?
Yes, Your Honor.
There is, okay. Well, I won't put him on a GPS because we can track him from the scram tether, quite frankly, but what I'll do is I'll modify his bond. I'll give him $25,000 personal recognizance bond, so I'll release him, but he has to be placed on a scram tether prior to his release.
Thank you, Your Honor.
Thank you.
Am I done?
Yes, Your Honor.
Good. All right, thank you, sir. Well, you can bring us Mr. Hill whenever you're ready. This guy. You're getting him. Who's on? Case was this? Where'd Cannon go? Okay. About to call her client back up. Court does recall the case, People versus Hill.
Yes, Your Honor, we did receive the results in this matter and I have discussed them with my client. And what the likely outcome will be based on that result.
Pardon?
And what the likely outcome will be based on that result.
Well, just so the record's clear, he had indicated to me that he hadn't taken it, hadn't been using, but his levels started out in May of cocaine, started out on May 7th at 424, then went down by May 9th to 353, but then by the 14th shot up to 889. So anything else you want to say? He's been using.
Your Honor, my client is just asking for a 1-week adjournment in this case. We're gonna have him screened for drug court to see if that's a suitable, a good fit
Probable
for him.
cause conference will be adjourned May 29th, 2 weeks on.
2 weeks. Thank you, Your Honor.
Absolutely. 2025, 9 a.m. His bond is revoked. Court calls the case, People versus Martez Dalton.
Rachel McDuffie for the people.
And Maggie, on behalf of Mr. Dalton, who is appearing to my right, Your Honor.
Your name?
Martez Dalton, sir.
I told you he was on the bus. I told you you'd get here, Miss Mackey. They didn't have any faith in you. I had all the faith in the world you were gonna get here.
John, I want to thank you for passing on the matter, allowing me time to get here, sir, and the time to matter.
You know what? I had to pass it because she was just screaming at me.
So, sir, I don't make no
Miss
excuses.
McDuffie wanted a bench warrant. I had faith in you, and so we gave you time.
Thank you, John. Thank you, Jan. I appreciate that. I was coming. I was gonna miss
No,
work for Nathaniel.
I appreciate you going through the effort to get here, sir. Really.
John.
All right. And you're requesting an adjournment?
Yeah, Your Honor.
Grant the adjournment. What are we trying to do in this? Oh, okay, I got it. All right. So probable cause conference, May 29th, 2025, 9 a.m. Bond continued. All right.
Thank you, Your
Thank you, sir.
Honor.
Yes, sir. Thank you, Jan, once again.
Thank you. Oh, that ended on a happy note for Miss Mackey, didn't it? Shocking. What? I didn't see that. You put a photo of a bus? Let me see. You drew. I asked for a picture, not like this. Thank you, Miss Mackey. Technically, it is a picture. All right, we'll stand in recess. We'll come back and set our next block shortly. Court stands in recess.
All right. All right. Court CA District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Dave Simpson.
You may be seated. All right, court does call the case of the People versus Clyde Moore Jr.
Here, Your Honor.
He's in Zoom. Go ahead, Madam AG.
Good evening, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Is this your case? Why should that be a shock? Gee,
Judge, I
yes.
apologize. Which case did the court call?
I mean, what did I call?
Yes.
Clyde Moore.
That is my case. Assistant Public Defender Chinazi Carey Akinruli on behalf of Mr. Clyde Moore Jr. Mr. Moore, state your name for the record, please.
Clyde Moore Jr.
All right, what are we doing?
Your Honor, we are actually going to ask for an adjournment. Mr. Moore did make some payments. I was hoping that we'd be able to get a resolution with the people, but we've still been in communication as to what the offer is going to be.
All right.
But I think he has made payments to satisfy the recommended reduction.
All right. They probably haven't appeared as of yet, or may have, who knows?
Your
All right.
Honor, Your
Yes.
Honor, I just tried to reach out to the PD's office this morning, but I didn't get in contact with anyone timely. My system shows unless he has more than one case that the arrears are now at 0. And typically
All right,
when,
0.
yes, and typically, even though I think the case is still charging, but typically when they are at 0, we do offer a misdemeanor disorderly. But I don't know if his attorney was aware of that, if she wants to discuss that with her client, or how she would like to proceed today. But
So it's at 0.
It's at
You
0.
just have to get everything worked out.
That's correct, Your Honor.
Okay. So why don't I do this? I'll adjourn the probable cause to May 29th, 2025, 9 a.m. And with that, out the payment doesn't, it won't click up. But okay.
Thank you so much, Your Honor.
All right, thank you. All right, thank you, Mr. Moore.
Thank you.
The attorney didn't even ask, so it just meant.
Nothing.
Court does call the case People versus Daniel White.
good afternoon, Your Honor, Assistant Attorney General Clarissa Williams on behalf of the people.
Assistant Public Defender Gabe Ellinger on behalf of Mr. White, who appears via Zoom.
Mr. White, can you state your name, please?
Yes, Daniel White.
All right, where are we on this?
Your Honor, I am asking for 2 weeks. I did speak with Ms. Williams earlier in the week, and if you got back to me, I unfortunately didn't get to it yet. So I just asked for a couple weeks so that we can, so I can discuss with my client where he's at.
All right. May 29th, 2025, 9 a.m. without objection. Bond continued. Thank you.
Thank you.
Court does call the case of the People versus Joseph Wynn.
Good afternoon, Your Honor, Assistant Attorney General Clarissa Williams on behalf of the people.
This is Yagi's case.
Yes, it
Well,
is.
don't everybody move at once.
I apologize, Your Honor. I apologize, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Nguyen.
Mr. Wynn, can you state your name?
Joseph Wynn.
Motorola. All right, where are we on this?
Your Honor, I am asking for one more adjournment. I know we have adjourned several times. Mr. Nguyen indicated that he is receiving a paycheck in a couple weeks, and he's going to, and we are hoping that with that payment, we will be able to continue towards resolution in this case.
So if I put it out to the 29th, that will happen.
So he says his paycheck, Mr. Nguyen, did I remember correctly? You said your paycheck's coming on the 30th?
In a couple weeks, 2 weeks on Friday.
On Friday, so the 30th. That's what I wrote down.
Okay. All right. So let me adjourn this out to June 5th,
Thank you, Your Honor.
2025, 9 a.m. Or as your invite indicates, bond will continue. Thank you.
Thank you.
And then this, I'll call it, but they haven't signed in.
Correct.
Court does call the case of the People versus Brian Brown.
Good afternoon, Your Honor, Assistant Attorney General Clarissa Williams on behalf of the people.
And this is Perkins. Is he in jail, Mr. Perkins? Todd Perkins? Can you send Todd Perkins? He's gonna lose his ability to appear via Zoom if he doesn't answer. This is Attorney General's last case. I don't. All right, counsel, just let me pass it and see if we're gonna see if we can get him on there. The facility that's housing the defendant hasn't signed in, but I don't know what Mr. Perkins has in mind.
Okay, Your Honor.
Okay. Let me pass it and then we'll get you out of here as fast as we can, as soon as we get him up.
Thank you.
Thank you. Court does call the case People versus Alexis Murphy.
And I'll be back with the people, Your Honor.
Let me know when Perkins.
Yeah.
Edward Lucas on behalf of Alexis Murphy.
Alexis Murphy.
Thank you. What are we doing?
Your Honor, I received the discovery today and was able to review that with her. I think the only thing outstanding is a 911 call that was requested yesterday. I'd like to set this for an exam. The 911 call should come relatively.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls the case of the people versus Maurice Cahey.
Henry J. Dollinger on behalf of Mr. K, who approaches.
All right. What are we doing?
Your Honor, we are here for a plea today. I will let Ms. Zenda place that on the record.
Your Honor, the defendant's going to be pleading guilty to count 2 with sentencing under 4A. Count 1 will be dismissed.
4A sentencing.
Correct, Your Honor.
May I have them sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? Yes. State your name, Maurice Cahey.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Sir.
You understand that?
Yes, sir.
Understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand about pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily of your own free will? And because you believe that you are indeed guilty of this offense? April 14th, 2025, at the location of 2700 International Drive, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do involving Charita Agee that makes you think that you're guilty?
Put my hands on her against her will.
You did what?
Put my hands on her against her will.
Okay. I get that, but what did you do? Do you push her? Did you?
She tried to attack me and I put my hands, I removed her off.
Okay, well, you run into the same problem.
I understand, Your Honor. If the court,
So I can't accept the plea. What do you want me to do?
if the court wouldn't mind passing the matter for a few moments.
Why not? We passed everything else.
I appreciate it, Your Honor.
I'll pass it. Mr. Perkins is here. Let me try to get that one. Court recalls the case, People versus Brian Brown.
Good afternoon, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good afternoon, Your Honor, and good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Brown. I'm not sure if he's
The facility that is housing him has not signed him in.
I guess I could waive his presence. If I could address an issue, Your Honor? I did speak with his new federal attorney. I'm not able to represent him federally because of a conflict. And I did speak with his federal attorney who has been working to try to find a solution to bond for him. And that was Allison Krieger is one of the newer federal attorneys that's working for him. So at this point, I know he was litigious in this matter in your court in Washtenaw County Circuit Court as it relates to the accrual of these charges. So that is an issue that is contestable. So at this point, Your Honor, we're at a PCC I would ask for another PCC if I could, one final one, to see what, if anything, Ms. Krieger's gonna be able to do. And how, because that's what I'd be asking, Your Honor. He's in custody,
All right.
he's in the federal system.
All right,
Even
I
if he's
will,
present.
without objection, I'll adjourn it. I don't think we're gonna be able to move on this right at this point as we stand here now, so. How much time are they looking, Mr. Perkins?
If I could come back, this is gonna be on a Thursday, Your Honor?
Always is, yep, pretty much.
Okay, just one moment, I'm trying to find it. June 5th would be a good date.
Probable cause conference in this matter without objection will be adjourned June 5th, 2025, 9 a.m. Or as your invite indicates, bond will continue. All right, thank you.
Thank you so much.
Yeah.
Thank you, Madam MG. Take care.
Okay.
Court does call the case, People versus Anishika. Got that right, King.
Assistant Public Defender, Janai Carey, on behalf of Ms. King, who's approaching judge.
Hello.
State your name for the record.
What's your name?
Anushka King.
All right.
Judge, we're still in negotiation, so we're asking for an adjournment for us to.
Hearing it this time. Probable cause conference, May 29th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
I think for the record, I know we had brought this up earlier. Ms. King did in fact get arraigned on that IBAC out of 35th District Court on May 7th, and our first pretrial is June 17th.
Sorry.
All right. Thank you.
Okay.
Court calls the case of the People versus Alexander Cronin.
That's good.
Good afternoon, Your Honor. Retained on for Central County Attorney.
And good afternoon, Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Cronin. Mr. Cronin, could you state your name for the court?
Good afternoon, Your Honor. This is Alexander Cronin. How are you?
And Your Honor, I just filled out a green sheet. I'm going to be asking for an adjournment for further discovery. I was just emailing with Ms. about the specific discovery that we are requesting.
Probable cause conference, June 5th, 2025, 9 a.m. Bond continued.
Thank you.
Yeah.
Thank you.
Thank you.
Court calls, thank you. Court calls the case, People versus Eric Coons.
I've addressed it, Your Honor. I've explained.
Just what? The
The,
fact that he only has half his pants on?
that is correct, Your Honor.
Okay.
All right. Your Honor, we are going to ask this case be set for a preliminary exam.
For a preliminary examination?
Yes, Your Honor.
I just want to confirm with counsel, previously reached out with a requested offer. I inquired whether she had looked into any sort of treatment program with Mr. Combs to facilitate that. And my last update as of April was that she was going to look into it with him. I want to confirm on the record that he is either rejecting that possibility and not interested in that course, or where.
Your Honor, to say he's not interested would be incorrect. He just, we're going to move it forward. He is considering the possibility of a specialty court. We've discussed specialty courts and the rigors associated with them. My client is not saying no, but in this moment, he is not saying yes. So I'm not saying it's not going to happen, just not today.
Okay. So discovery is complete.
To my knowledge.
People have their witnesses available to 27th.
We'll try, Mr.
Preliminary examination, May 27th, 2025. 9 a.m. in person before judge. Fresh hour.
Okay.
Bond will continue. Thank you. Court does call the case of the People versus Maxwell Lawson.
Yaki, Assistant Public Defender, with and on behalf of Mr. Lawson, who's approaching. Mr. Lawson, could you state your name for the court?
Maxwell Lawson.
Thank you.
Forgive my clarity, Your Honor. I was on my way to work this morning when I remembered I had court.
Okay, at least it's got whole pants on. Go ahead.
Your Honor, The people and I have previously discussed a potential offer. At this time, we're asking that it be set for preliminary examination. I've been trying to find a recovery court to no avail in Wayne County that is accepting transfers, and I've spoken. I won't go into detail. At this time, we're asking that this case be set for preliminary examination.
Discovery is complete.
To our knowledge, yes.
Witnesses would be available the 27th.
I'll try, Your Honor.
Preliminary examination, May 27th, 2025. 9 a.m. That's before Judge Washington. Bond continued.
Thank you.
Thank you, Your Honor. Thank you. Court does call the case of the people versus Latrice Lee.
Michael Gash, tender for Ms. Lee, who's approaching, Judge.
Your Honor, if I could approach, I do have an advice of rights and sentencing judge waiver.
Okay.
State your name, Mr.
Latrice Lee.
I don't care. And
Oh, I'm sorry, Judge. I
don't have a care.
Yes. My apologies, Judge.
All right, I have a plea form that indicates that the defendant will be pleading to the stated count 2 of operating with a high BAC, as well as count 3 attempted resisting and obstructing. The operating with a high BAC is a misdemeanor punishable by up to 180 days in jail, and the other offense up to 1 year in jail. Upon our successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of it.
That's correct, Your Honor.
That is a correct recitation, Judge.
All right, before I take the plea, though, we have a violation.
Oh, I didn't know. May I approach?
May I approach this way, Your Honor?
Yes.
Violation.
There we go off. No, you know what? No, never mind. No, it's in the wrong file.
Oh, that's okay.
It's in the wrong file. It's okay. It was somebody else's violation.
Okay, I know, I'm,
But you look shocked? Never mind. All right, may I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
yes,
State your name.
Latrice Lee.
And is she pleading guilty? or-
She's pleading no contest, Judge. I did provide the police report yesterday.
Yes, I have the police reports, I just don't. Alan? Am I in
It must be
danger?
working.
No, am I in danger? Are you sure? You just telling me?
Oh, wow.
So you're gonna plead no contest. Any admissions?
What?
So,
But that doesn't mean it went away. Maybe somebody be checking that?
don't look at me. He pointing
Huh?
to me.
You tell me, I'm, my faith and trust is in you. If you're telling me I'm okay, I'm okay. Ma'am, it's just court's understanding you're gonna plead to no contest to 2 misdemeanor charges. Is that
Yeah.
correct?
Yeah,
The first one being the charge of operating with a high BAC. That is a misdemeanor, which is punishable. Misdemeanor punishable by up to 180 days incarceration, up to a $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
yes,
The other charge is the offense of attempted resisting and obstructing. That's a misdemeanor, punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
yes,
All right. Do you understand what a no contest plea is?
yes,
2 things about a no contest plea I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these charges. You understand that?
mm-hmm,
Yes?
Yes,
All
yes,
right. The other thing that you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
yes,
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
yes,
You understand that?
yes.
All right. Basis for the no contest plea.
Potential civil liability, Judge.
Ma'am, to the charge of operating with a high BAC, how do you plead?
Guilty.
You plead no contest.
Oh, no contact.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
No contact.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes,
Any question regarding any of those rights?
no,
All right. Please look at paragraph 5. Those are your rights which are part of a trial. And by pleading no contest, you're giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of?
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily and of your own free will?
yes,
Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 24-81414. Any objection to the court having reviewed those reports?
No, Your Honor.
None from defense.
Based on the court's review of the report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court?
I think we're satisfied.
Defense is satisfied, Judge.
Court will accept the defendant's no contest pleas to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
June 24th at 10 a.m. with Judge Barr.
June 24th, 2025. What time? 10 a.m. before Judge Barr. And will continue.
Thank you, Your Honor.
okay.
Actually, if I could ask the court to address the court on a bond condition, Judge.
Yes, go ahead.
Thank you. Ms. Lee has been testing faithfully since the onset of this matter. I think she has had nothing but negative tests. We'd ask the court to remove the testing obligation at this time.
I don't need a response. I'm not going to do that. At this point, her bond will continue.
Thank you, Judge.
Okay.
Court does call the case. People versus Megan Moses.
People.
Assistant Public Defender, Cedric, I can really, Your Honor, on behalf of, but unfortunately not with Miss Megan Moses. Is she on Zoom? Yes, she's on Zoom.
Ma'am, state your
Right
name.
here. Megan Moses.
Thank you.
Judge, we're requesting an adjournment. Our negotiations are requiring that Ms. Moses make some significant payments, so she's working on that, and I just need to talk with the people to see how much time they're willing to give her to make those payments.
Well, is she gonna?
Hello.
Yeah, hang on a second, Ms. Moses.
Okay.
Well, is she gonna? I mean, how much time are we looking at?
Well, Your Honor, I think that I will just be asking for the normal 2-week adjournment, and then once I find out from the people exactly what the terms of the agreement would be, I guess at that point I can present that to the court.
All right. May 29th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the, thank you, Ms. Moses. Court calls the
Okay.
case People versus Tremaine Pender.
That's for the people.
And Mackin, we have a Mr. Pinder who's appearing to my right. Please state your name for the record.
Tremaine Pender.
He's wearing shorts, Your Honor, yes.
Why?
Saw you looking at his shorts.
Well, I wasn't looking at his shorts. I don't know that that's, should be stated.
Yeah, I was at
I'm just
work.
wondering where the rest of the pant leg is.
No, I'm sorry. I was at work. I'm a carpenter, so I'm in the sun all day. I wasn't really thinking about my court session today. Because I just left work.
You weren't thinking about us.
No, I was thinking about you.
Oh.
I was thinking about you, but I'm outside in the sun all day. It's hot out there. I wasn't thinking, I'm sorry about that. I apologize.
Okay. What are we doing?
Your Honor, we request to set this matter for preliminary examination and all discovery is complete as far as we are aware.
Preliminary examination, well, people have their witnesses available the 27th. Preliminary examination will be set May 27th, 2025, 9 a.m. before Judge Freshour. Bond continue. Thank you.
Thank you, Your Honor.
Thank you a lot.
Court calls case People versus Melton Rucker.
And I need an accept that, Your Honor.
Equipment. Will that work for you, sir?
Yes, sir.
All right.
Good afternoon, Your Honor. Ray Pan, Assistant Prosecuting Attorney on behalf of the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Rucker, Your Honor. Mr. Rucker, can you state your name for the record?
Melton Rucker. All right.
Your Honor, Mr. Bellinger has submitted to me a very detailed litigation report. I have looked through it. We are in negotiations, so I believe we need a little bit more time.
All right. Will 2 weeks be enough to try to?
I think that would be absolutely fine.
Okay, that works. Thank you, Your Honor.
Probable cause conference, May 29th, 2025. 9 a.m. or as your invite indicates, bond will continue.
Okay.
Thank you.
Thank you, Your Honor.
Thank you.
And don't leave without
Thank
getting
you,
this
sir.
from you. Okay?
Court does call the case, People versus Kirby Snyder.
Andrew Childers, attorney on behalf of Michael Gaddy, Assistant Public Defender on behalf of Ms. Snyder, who's making her way to the podium, Judge.
Oh, it's fine. Don't worry about it. I'll let you finish fixing. You okay? State your name.
Kirby Snyder.
Thank you. All right, what are we doing?
Your Honor, this matter, well, we're asking for a brief adjournment. We have submitted the paperwork for the recovery court to Judge Kunke's office. We have not heard back yet. I did Teams Ms. Noveski earlier and to see if they had addressed her today, but I haven't heard back.
All right.
I do have a green sheet, Judge. I'm sorry.
Adjourn this to June 5th, 2025, 9 a.m. Bond continues. All right. Thank you, ma'am.
Thank you.
Thank you, Your Honor.
Court calls case People versus Virgil Stafford.
Brian Bowling on behalf of Mr. Stafford, who hopefully should be on Zoom, Your Honor.
Yes, I am.
State your name, sir.
Virgil Lee Stafford III.
Thank you.
Judge, Mr. Stafford met with the examiner at the Forensic Center on Monday, so we're just waiting that report.
I have this set for a probable cause. Shouldn't be, should it? Huh? I think it should be set for a competency here. All right. So you met with when?
Monday,
Monday.
9 a.m. Yep.
So let me then set this. We can always move it up, but what I was going is basically to the end of June. Let's see where we are. So June 26th. 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Calls case of the People versus Kevin Stevenson.
Andrew Childers, on behalf of the people.
Stephanie Kane, I'm here on behalf of Mr. Stevenson, Your Honor. I have a green sheet. Your Honor, Mr. Stevenson is currently being housed at the Calhoun County Jail. A writ was not done. I did attempt to do this by stipulation. However, me and the prosecutor, we couldn't agree on, we wanted the court to pick the next date. Yeah, we were just trying to get the next date. I mean, in a good way, though. So we were just looking for the next date from the court. He won't be released until the end of May.
So.
Yes, Your Honor.
Oh, so it's not that they couldn't pick a date, they're trying to submit it after the deadline. And we said no. Oh, they didn't submit anything.
No, Judge.
Echelon of people.
So it was, so they were like,
Judge, no.
That's what was going on?
No, so we were working really good on it. I wanted to go further out and she was like, why don't we let the court decide? And I said, I don't mind, that's fine. And so then we came here for the court to decide what date the court wanted to do, knowing that he's not going to be released until the end of May.
Are you,
Stan reached out to me with the proposed tip in order adjourning to June 12th. Sure, if the court becomes going right that far.
I'm not, but I will, it with the understanding that he's not gonna be released till the end of May,
There.
so. Does that mean we shouldn't do it?
When we spoke to him, he said he's gonna be released the end of May. So we shouldn't, finally has been down, so I couldn't get that date. Hopefully it comes back up. So, Your Honor, thank you, June 12th will work for us. Thank you.
June 12th, 2025, 9 AM, or as your invite indicates, bond continued. She just left. She didn't even wait for me to finish. She just turned her back and walked away. Sounds like something a supervisor in that office needs to know about. Court calls the case People versus Elijah Stewart.
Good afternoon, Your Honor.
So if you hadn't gotten up in such a hurry to walk away, you would have been there.
I would have been there.
Never mind, go ahead.
I'm slacking today, Your Honor. Stephanie Cannon on behalf of Mr. Stewart, who is present to my right. Please state your name for the record.
It is Elijah Stewart.
Thank you.
Your Honor, we're just gonna ask for a 2-week adjournment on this matter. We're doing some investigation and we do believe that we will be fine by 2 weeks from today.
No objection.
Probable cause conference, May 29th, 2025, 9 AM. Bond continued. Bring in lunch.
Thank you, Your Honor. Appreciate you so much.
No, you
Good
don't.
morrow, sir.
What?
Good morrow.
Your Honor? Wow. Just go. Wow. Court calls the case People versus Courtney Taylor.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Jay Ballinger on behalf of Ms. Taylor, who appears via Zoom. Ms. Taylor, can you please state your name for the record?
Courtney Taylor.
Thank you.
Your Honor, we are just seeking to set this for preliminary examination. Discovery is complete to the best of my knowledge.
People have their witnesses available the 27th.
We'll do our best, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 AM. That is before Judge Washington. Bond will continue.
Thank you.
Court calls the case of the People versus John Terry.
And Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of, but unfortunately not with Mr. John Terry.
Really?
But we
What
do
a
have
shock.
an explanation.
Huh?
We have an explanation.
You
Your Honor.
do?
We do.
Would it have anything to do with his violation?
Oh, yeah.
Okay, so go ahead.
So, Your Honor, I did receive a message from my office today indicating that Mr. Terry called this afternoon prior to the 12 o'clock block, stating that he was having a medical emergency. Unfortunately, I was not able to follow up to find out more details about that. I do understand based on the bond violation that the court is going to put a bench warrant out for my client, but what
I haven't decided.
I'm assuming.
You're assuming that.
That's correct. Well, I would ask, Your Honor, for an adjournment in this matter. Yeah.
No, but go ahead.
So what we were asking, I have been able to speak with Ms. Douglas about this. So what we're asking is that although the court will most likely put the bench warrant, we're just asking that it be delayed to give us an opportunity to get that information to confirm his medical emergency. And I know it is problematic because he's got the bond violation.
I don't need a response. Nice of you to ask me, I can really, but bench warrant will issue for defendant's failure to appear bond, $25,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
You're welcome.
Yeah.
And I know you didn't mean that. Thank you. Court calls the case, People versus Delco Thomas.
Anna Mackey on behalf of Mr. Delco.
Alexander, on behalf of the people, Your Honor.
Is it Thomas Delco? I got it backwards. Your name, sir?
Yeah, I'm here.
Oh,
Delco Thomas.
Okay. That's not bad.
what'd you say? Uh-oh.
Why did I say that? Because you said it backwards.
Oh, Your Honor, at this time, we are requesting to set this for preliminary examination, and all discovery is complete as far as we are aware.
People have their witnesses available on the 27th.
We'll do our best, Your Honor.
Preliminary examination will be in person, May 27th, 2025, 9 a.m. That is before Judge Fresho. Where's that?
Here, yeah.
Oh. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Louis Feraldi.
Andrew Childers, appearing on behalf of. Brian Bowling on behalf of Mr. Feraldi, I'm sorry. State your name for the record. Waiver.
Louis Feraldi.
Thank you.
Your Honor, at this time, Mr. Feraldi is prepared to waive his right to a preliminary examination.
All right, is that correct, sir?
Yes, sir.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Knowledge receipt of the information, waive its formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
July 17th at 1:30 p.m. with Judge Slay.
July 17th, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Bond continues.
I'll give you this going.
Court calls the case of the People versus Jelani Wright.
And for Douglas for the people?
Mike Gandy, Assistant Public Defender on behalf of you, right? Thank you. Your Honor, this is a date and time for, why am I saying that? You know why we're here. Your Honor, I've had a chance to speak with Ms. Douglas. This PCC was set today to see if Mr. Wright could post the some restitution as bond. He's not able to do that. We'd ask the court to adjourn the matter out to allow him to raise some funds. I've talked with Ms. Douglas. She doesn't have any objection to that.
How much time is he gonna need?
Would the court consider 6 weeks?
The only adjournment for this purpose, I don't like going out that far, but I'll adjourn it to the June 26th.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will.
Thank you, Judge.
Court does call the case of People versus Maurice Cahey.
Alexander, on behalf of the people, Your Honor.
Ready, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Cahey who approaches. Mr. Cahey, can you please state your name for the record?
Okay.
Your Honor, we have had time to talk. We are ready for a plea at this point.
All right.
Thank you for your patience.
I think we had gotten to the factual.
That's correct.
All right. And so, sir, I'll ask you again on April 14th, 2025, location of International Drive, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do regarding a Charita Lee, a G?
Yeah. I shoved her against her will and she fell down.
All right. You didn't have permission to do that, did you?
No.
All right. And who is she to you?
My ex-fiance.
All right. And on that same date, well, I guess that's the only charge, right? No, we have a DV. We have the DV. We don't have an hour. All right. That's why if I complied with the court rule, would it be proper to accept this defendant's plea?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
June 30th at 10 a.m. with Judge Washington.
June 30th, 2025, 10 a.m. before Judge Washington. Bond continued with it.
Thank you, Your Honor. Contact probation. Okay. You're all set. Take care.
Yes, you may.
Good afternoon, Mr. Interpreter. You're in front of the Honorable J. Cedric Simpson out of the 14A District Court, Washtenaw County, State of Michigan. Our number is 1423, and we need your assistance with one matter this afternoon.
Yes, this is the interpreter speaking. I am ready.
Thank you, sir. Can you please raise your right hand to be sworn? Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, to translate from English into Spanish and from Spanish into English in the manner now before the court to help you God?
Yes, I do.
Thank you.
And good afternoon, Mr. Interpreter.
Good afternoon, Judge.
Court does call the case of the people of the state of Michigan versus Dalton Castillo.
Bien, esta es la causa de el pueblo del estado de Michigan contra Dalton Castillo.
Ali Zenda, on behalf of the people.
Aquí tenemos a Alisandra a nombre del pueblo.
And Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Mahano Castillo.
Aquí tenemos también a la defensora pública a nombre del señor Castillo.
This is the first probable cause conference. I did fill out a green sheet. I am requesting to adjourn to obtain the 911 call.
La señora está solicitando, dado que es la primera causa probable, obtener la llamada del 911.
However, I would ask if the judge would hear a bond condition request.
También le estoy solicitando al juez una condición para requerir salir bajo fianza.
My client is requesting consensual contact. He indicates his family has told him that the complaining witness in this case wants contact. I don't know if the people have had any contact with her.
Mi cliente lo que está solicitando es un contacto consensuado, ya que no hay ninguna queja en el contacto continuo.
Your Honor, we do not have confirmation that she would want contact.
Mr. Interpreter, she said, we do not have confirmation that she wishes contact.
Lo que sucede es que no tenemos confirmación de que ella desee tener contacto.
In that case, I don't know if the court would potentially consider giving us only a week adjournment. I mean, I will follow up about this, but I know Mr. Mahano Castillo is eager to move this case along.
En ese caso se solicita, si el juzgado lo considera, por lo menos un permiso por lo menos de una semana, de por sí que el señor Castillo quiere avanzar con este caso.
Matter will be adjourned to May 29, 2025, 9 a.m.
Sí, el caso se traslada para mayo 29 del 2025 a las 9 de la mañana.
This bond will continue with the conditions, including no contact.
Sí, las condiciones continúan como están acerca de no tener contacto.
Thank you.
Understood. Thank you, Your Honor.
Gracias, señoría.
Thank you, Mr. Interpreter. I do appreciate it.
You're very welcome, Judge. Have a good day.
All right.
Your Honor, may I swear in Mr. Hussein for the Arabic interpreter?
You may.
Good afternoon, Mr. Hussein. You're in front of the Honorable J. Cedric Simpson out of the 14th District Court, Washington County, State of Michigan. Our number is 1423.
1423. This is
When
Hussein.
you're ready to proceed.
This is
Go ahead.
Hussein, your Arabic interpreter. My ID is 247160.
Thank you, sir. Can you please raise your right hand to be sworn?
I'm sorry, what was your access code number again, please?
1423.
Yes, how may I help today?
We need your assistance with one felony matter. Can you
Yes,
please raise your right hand to be sworn?
Yes, Your Honor.
Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Arabic and from Arabic into English? in the manner now before the
I do,
court
Your
will
Honor. I do, Your Honor.
Good afternoon, Mr. Interpreter.
Good afternoon, Your Honor.
The court does call the case of the people of the state of Michigan versus Afi Alawa.
Your Honor, Hannah Mackie on behalf of Mr. Alawar, who is to my right. Oh, sorry.
Go ahead, Mr. Interpreter.
المحكمة تنادي على قضية السيد رافي الأعور وتقول أنه رافي الأعور هو بجانبها.
Your Honor, I'm sorry, I think Hannah may not be hearing or understanding.
Understanding, it's the dialect.
He doesn't understand the dialect.
Is it Lebanese?
This is Arabic. I'm speaking standard Arabic.
Okay. Would you
Just-
understand?
No.
Maybe you didn't hear him.
Pardon?
Maybe he just didn't hear him well.
Okay. سيد عفيف سامعني؟ تسمعني عفيف؟
نعم.
معك مترجم اللغة العربية اسمي حسين.
مش عم بفهم عليك.
He's not understanding.
To the interpreter, you're indicating that he is indicated to you he is not understanding.
Correct, Your Honor.
Do you know what dialect he needs? Does he need Lebanese?
Lebanese dialect, yes, Your Honor.
He needs Lebanese dialect. Okay. I will adjourn this out to June 5th.
سنقوم بتأجيل الجلسة إلى 5 شهر 6.
9 a.m. and we will seek a Lebanese interpreter.
إلى الساعة 10 صباحا وسنبحث عن مترجم باللهجة اللبنانية.
Okay.
I think he just couldn't hear. I think it was the hearing. It wasn't.
Thank
the-
you.
Wow.
I thought the interpreter told me he could not understand.
What he said was like, he just does like, like, it doesn't mean like actually like understand. I think he just meant like understand, like I can't hear, understand. Like, it's just.
Sir,
No.
ask him, can he understand the interpretation in this case?
أنت
Yes, sir.
فاهم الترجمة في هذه الحالة؟
فهمت انه 5 شهر 6 اجل الدعوة لكذا، هذا اللي فهمته.
What I understood that the case was postponed to June 5th. That's what I understood.
That what you wish to have happen today?
No, Your Honor.
What?
هل هذا اللي تأمل أنه يحصل اليوم؟
Like شو like what?
يعني أنه تتأجل؟
No problem, yeah. Yes, it's a good.
Okay, what do you wish the court to set?
It's set for exam, Your Honor.
What wish the court what?
Could you interpret that they wish to have the matter set for preliminary examination?
هل تحب أنه تكون الأمر يعني يفحص بفحص ابتدائي؟
كيف يعني؟ كيف؟
How is that?
I will set this for preliminary examination, May 27th.
راح نأجل هذه الفحص الابتدائي إلى يوم 27/5.
And Your Honor, just for the record, we can't cover the people. I don't think we got that.
I'm sorry.
For the record, Marie Tanhoff for the people, I don't believe we got that far initially. Just for the record, my experience.
Got how far? I'm sorry. You lost me.
Okay, thank you, Your Honor.
All right. I'm going to set it for preliminary examination. May 27th, before Judge Washington.
Thank you, Your Honor.
And I will send her my best of luck and blessings. All right. Thank you, sir.
شكرا لك.
Thank you. Thank
All right.
you.
Thank you, Mr. Interpreter.
Anything else you can help with, Your Honor?
No, sir. Thank you.
My pleasure always. Thank you for calling Language Line Solutions and have a good day.
All right.
Thanks, bye.
That's the end of that block. All right. Court is standing in recess.
All rise.
Court does call the case of the people of the state of Michigan versus Cheryl and Jersey.
And then on behalf of the people, Your Honor.
Attorney Martin McManus, P 41543, on behalf of Cheryl Andrzejczyk.
You there, ma'am? Can you state your name, please?
My name is Cheryl May Andress.
In Jessica, okay. All right. What are we doing on this?
Your Honor, I did have a chance to speak with the prosecutor. We're asking this to be adjourned down the road for a further probable cause conference.
Then what are you guys looking at?
Looking at June 5th, either in the morning or afternoon.
Okay. I'll set it for June 5th, 2025. I set it at 9 a.m. Your block will likely be in the afternoon, counsel.
Okay, thank you very much, Your Honor.
All right. Thank you.
Thank you.
Bond continued. Court calls
Thank
the
you.
case of the people versus Marissa Bridgman.
Good afternoon, Honor. Ray Tennant, attorney on behalf of the people.
Good afternoon, Your Honor. Sam Bernstein for Ms. Bridgman. Should be on Zoom.
Bridgman, can you state your name, please? You got her or no? I don't see her. Well, no.
Oh, so go back over there and text her.
What?
It was, she'll be here. It must be a connectivity issue. Can we pass the matter for a moment, Your Honor?
You're so like made that up.
I feel like it must be it. I've talked to her all week. I mean,
Did you?
yes, Your Honor. I have a strong feeling.
Was it a good conversation?
They were-
Apparently not.
She wanted to see Your Honor in court.
Yeah, that's what I'm thinking.
She wanted to see Your Honor, so she's going to be here. Could we please pass it?
Oh,
for a
is
moment?
that right?
Yes.
I'll pass it. Court does call the case, people versus Leslie Brown. So apparently you're not making a call right now. Okay.
Mr. Brown's present, Your Honor.
Yes, he is. Sir, state your- Oh,
Good afternoon, Honor. Ray Tennant, assistant prosecuting attorney on behalf of the people.
Sam Bernstein for Mr. Brown, Your Honor. Could you please state your name?
Leslie Brown. Thank you, sir. All right, what are we doing?
Your Honor, discovery is complete. We're asking the court to please set this for exam.
Okay. People have their witnesses available on the 27th. Preliminary examination in person will be set May 27th, 2025, 9 a.m. That is before Judge Washington. Bond will, with its conditions, will continue.
Your Honor.
Thanks, Brown.
Court does call the case people versus Priya Collins.
And then on behalf of the people, Your Honor.
Good afternoon to this honorable court. Attorney Carla Marable, P number 62755 on behalf of Priya Collins. Ms. Collins, please state your full name for the record, ma'am.
Priya Miracle Collins.
All right, thank you. All right, what are we doing?
Your Honor, the discovery, we have all the discovery. We just need to set it for preliminary exam.
People have their witnesses available the 27th.
We'll do our best, Your Honor.
Preliminary examination in person will be set May 27th, 2025, 9 a.m. That's in person before Judge Freshour.
Thank you. I will see the court on the
All right.
27th. Thank you.
Thank you.
Thank you. Bond continued. Court does call the case of the people versus Darian Cotton.
My P number is.
All right, sir, we're having problems hearing you. All right. Mr. Cotton, can you state your name, please? Mr. Cotton, can you state your name? Court calls the case people versus Lawrence David.
Good afternoon, Honor. Ray Tennant, assistant prosecuting attorney on behalf of the people.
Good afternoon, Your Honor. Nicole Blankbacker on behalf of my client, Mr. David, who is present as well.
Sir, please state your name.
Lawrence David.
Thank you. All right, what are we doing?
Your Honor, at this point, we would like to set this case for the preliminary exam.
You have all of the discovery, counsel?
Your Honor, we believe we do. We've asked a number of times, and at this point, I believe we do.
Okay. People have their witnesses available the 27th. Preliminary examination in person will be set May 27th, 2025, 9 a.m. That will be before Judge Washington.
Thank you very much, everyone.
Thank you. Bond continue.
Thank you. Take care.
Thank you. Court does call the case of People versus Janet Evett.
Council line for the people.
Good afternoon, Your Honor. Jonathan Sachs for Ms. Evich.
Evich. I have a plea form in front of me. Is that what we're doing today?
That's correct, Your Honor.
All right. Plea form indicates that the defendant will be pleading guilty to the charge of use of methamphetamine, the 1-year misdemeanor. Upon our successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor. Your Honor, I have spoken to the assistant prosecuting attorney, and if Your Honor would entertain it, there's no objection to shifting straight to a fines and cost sentencing. This is out of this district, and I can talk to as to Ms. Evich just and show you a bit of documentation as well, if you would consider that.
Well, I don't know if I'll consider it today, but I mean, I typically would send this over at least to have it looked at by my probation department. It may end up as a fines and cost sentence, but I don't know that I do that today.
And for the record, Your Honor, I did discuss that with defense counsel that I would not be opposed to a fines and cost sentence today if the court would consider it. I understand the defendant is on parole. She's being supervised and doing very well. Did not want to put her on 2 forms of probation, but I completely understand if the court wants to have her screened first.
That's correct, Your Honor. And I just add to that this is not a parole violation. This is something that took place before the start of that parole.
I have her sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? So help you God.
Yes, sir.
State your name.
Janet Evich.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes,
Are you on probation or parole?
I am on parole.
All right. And this occurred prior to your placement on parole?
Yes, sir.
Correct, okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No,
Has anybody threatened you or coerced you?
no, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, I am.
October 24th, 2023, at the Huron Valley Correctional Facility in Pittsfield Township, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
I did, sir.
Had you used it
I did not use it, but it was in my possession.
and you were intending upon?
Yes, I was. I was,
And you knew
yes.
what you were intending
I
upon
was.
using was methamphetamine?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Yes, Your Honor. Thank you.
Court will accept the defendant's plea. I'm guilty to count 2. Count 1 is dismissed. So you were, I didn't look at that before when I was telling you that you were incarcerated at the facility when this occurred.
Yes, sir, I
You are
was.
now out on parole.
Yes.
All right.
Anything
you'd like to say before I impose
I
sentence?
am due to be off parole next month. I've enrolled in college. I've done everything forward, nothing backwards in life. I drug test randomly. I show up every day on time, every month on time. And I've been doing great. I've been sober. I was in the MAP program when I left incarceration and I was able to get off that. I still stand here today sober, over a year later. I stay at home with both of my children. That's why I enrolled in school, trying to find something for stay at home. I'm still fighting to get my license, but that's just more of I have to go to court because of relevant to the first, what happened. But I've been out doing great. I've changed a lot. Back then I was in a bad spot. I've been in therapy 6 years, the same standing therapist, I've been doing really good.
All right.
And Your Honor, I have spoken to her parole agent this morning who confirmed that Ms. Evich has passed all her random drug testing and is doing everything she's supposed to be doing on parole, that it's going very well.
How long were you incarcerated?
4 years, sir.
This seems like this was a mistake along the way to where you're getting to now, right?
It was, sir. It honestly was. You know,
So,
it was, yes.
okay, fine, the cost of $125 state minimums. 365 days incarceration, credit 365 served. Good luck to you.
Thank you.
Thank you, Your Honor.
Court does call the case, People versus Lewis Goodine.
Good afternoon, Your Honor.
Andrew Childers, on behalf of the people. Mr. Goodine?
Yeah, he's on the Zoom.
He what? I know, but he's not, his camera's not on and he's not answering.
Let me give him a call real quick. Because he was on a few minutes ago.
No, don't quit talking. I'll pass it.
Yeah.
Court calls case, People versus Shaquanda Hall.
Good afternoon, Your Honor, David Canine for defendant.
What one the hell? What was in the hell? Shaquanda Hall. She's not on Zoom. This is a beautiful day.
I'm sorry, Your Honor.
Pardon?
I said I'm sorry. She's in California and I passed along the information. I won't say any more than that.
Okay, well, she's not here. Bench warrant will issue for defendant's failure to appear.
Okay, understood, Your Honor.
Bond will be set in the amount of 10,000. Cash surety. That warrant will issue immediately.
Okay, sorry.
Thank you. Court calls the case, People versus Christopher Jackson.
Haley Zen on behalf of the people, Your Honor.
Kyle Bedell with and on behalf of Mr. Jackson. Mr. Jackson, please introduce yourself to the court.
I'm named Christopher Jackson.
And Your Honor, today's date and time set for probable cause conference. We are still waiting on some additional discovery. I know APA Zenda has done her part to sort of start getting it for us, so we're just asking for a brief adjournment at this point.
And that's correct, Your Honor. I did put in a request for meeting yesterday as well as
During this matter, May 29, 2025, 9 a.m. Bond continue. Court calls case, People versus Elliot Kazan.
If you were to make the group people.
And Your Honor, Joe Simon on behalf of Mr. Kazan, state your name, Elliot.
Elliot Kazan. I have a bone to pick with you, Mr. Simon.
Again, I mean, so what's that, Your Honor?
So, was it yesterday? Well, I'm talking about.
When Mr. Guerin covered for me, that was yesterday.
Well, it wasn't covered. We got messages that both of you were down at 15.
It's true.
Guerin gets here. I said, where's Simon? The next thing I know, Guerin says he's covering for Simon because Simon didn't want to come down and see you, Jack. No, it was really a nasty comment that he said you made. So I just want you to know, no hard feelings.
I appreciate that so much, Your Honor. I was not able to get out of there, so thank you. And I thanked Mr. Guerin appropriately too.
All right, what are we doing? Okay, it didn't happen that way at all. That's okay.
Your Honor, I made a proposal of resolution to Ms. McDuffie. Ms. McDuffie made a proposal of resolution to me. We're close. She asked if I would supply her some additional information she'd consider, but not necessarily commit to the resolution I'm requesting. So we're asking for a brief adjournment of PCC.
May 29th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court does call the case, People versus Daniel Lamb.
To make the group people.
Your Honor, David Candia. Gary?
Your Honor, we do
state your name for record.
Daniel Lamb, Your Honor.
Thank you.
We are waiving, Your Honor.
All right.
I could get the form to you sooner.
Sir, is that correct? You're waiving your right to a preliminary exam?
Yes, Your Honor.
You understand that that's a proceeding where the people have to show by probable cause that the offense is alleged, or the offense alleged was committed and that you committed.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right Preliminary examination having been waived, defendant's bound over to circuit court on a single count. Charlie, your turn.
Waive, Your Honor. Defender stand mute.
Defendant having waived for reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 9th at 1:30 PM. Judge Conlon.
Conlon.
Yes.
Yep.
July 9, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Marco Nanny.
That's a lot of people.
David Shannon, on behalf of Marco, a nanny who's approaching, Your Honor. Marco, please state your name for the record.
Marco's on here, Your Honor.
He has been screened, assessed, and accepted into felony treatment court.
Got it.
So we are waiving the preliminary examination.
That a correct statement?
Yes, Your Honor.
All right. Understanding that that's a hearing where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
And you understand you'll not have that hearing, proceed to circuit court for further resolution, right? Okay. People also waive their right.
We do.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following. Mr. Shannon.
And Your Honor, waive and stand mute.
Defendant having waived formal reading, standing mute as to all 3 counts. Court will enter a not guilty plea. Pretrial will be set for
July 8th at 1:30 PM with Judge Conlon.
July 8, 2025,
Your Honor, I have a update.
1:30 for Judge.
It's July 3rd. They want him there on July 3rd, Tuesday the 3rd, because he's going into treatment court on Thursday the 5th.
Okay, I hear you. However, we are given dates.
All right.
So whatever mess is being created by that whole thing.
I will go
let
with
them
Ann.
solve
I
that
will go with
downtown.
Ann in this.
All right, I'm gonna give you the date I have.
All right.
Which is the 8th, and they'll move it up if they need to.
Perfect.
All right. Bond will continue.
Thank
All
you.
right, good luck to you.
Thank you, Your Honor.
Thanks.
Court calls case People versus Ricky Lee Parkman.
Good afternoon, Your Honor. Jennifer Winstead, P78369, appearing on behalf of Ricky Parvin. Please state your name for the record.
Ricky Parkman. Thank you. All right, what are we doing?
We're very close to a plea agreement. Ms. Winston and I have been emailing back and forth, and there's been some issues. Mr. Parvin trying to get his pilot license, so it's waiting through what the FAA deals with conditions. We're trying to sort that out. I think that we would have, the next time we will have some agreement in place. So we're just looking for an adjournment for that purpose.
Okay, how much time is it gonna take for you guys to try to get it?
Well, we don't pick dates, so.
I know you don't pick dates. That's why I was trying to be generous and ask for, actually, I was trying to be generous to counsel here and ask how much time you needed. I don't care.
Thank you, Your Honor. My client is actually, we had sought permission last time we were here for him to attend his daughter's wedding. So we were gonna ask.
How'd that go?
It's still gonna happen.
Yeah, it's May 28th
Oh,
through June
May-
1st.
Oh.
So we were
that's
gonna.
Still going.
We were
Still
gonna.
going?
Yeah.
You still like him?
Yes.
Okay, I'm just checking. All right. June 5th is available, or the 12th, whichever you.
June 5th is great, Your Honor.
5th, all right. Probable cause conference, June 5th, 2025,
Thank you, Your Honor.
9 a.m. Bond continued. Thank you.
Thank you. Have a good day.
Take care. Court calls the case People versus Todd Teachout.
Jennifer Douglas for the people.
Good afternoon, Your Honor. Dan Garrett on behalf of Todd Teachout. Todd, just state your name.
Pat Teachout.
Thank you.
I'm asking for an exam date, please.
A lot of them today. It is. Your discovery is complete.
I believe it is, Your Honor. Thank you.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court calls the case of the people versus, is it Yu Chen?
And is that not exactly people, Your Honor?
Good afternoon, Your Honor. Dan Garrett on behalf of Mr. Chen. He's on Zoom. Mr. Chen, can you?
Yes. Could you unmute and state your name? Thank you.
I'm Yihui Chen.
All right, thank you.
Asking for an exam on this as well, Your Honor.
Discovery is complete.
Yes.
Do other witnesses available the 27th?
We'll do our best, Your Honor.
Preliminary examination, May 27th, 2025, 9 a.m. That is before Judge. Fresh hour. Bond will continue. Mr. Garrett, because we would need to note the file. I know you waited for today. Are you going to need an interpreter for
He
that?
told me last time he absolutely does not need an interpreter.
Okay.
Thank you for checking.
Court does call the case of the people versus Lewis Goodine. Recall.
Andrew Childers, attorney on behalf of the people.
Good afternoon, Your Honor. Raymond Burkett appearing on behalf of Mr. Goodine. And Mr. Goodine, would you introduce yourself to this honorable court?
You're muted. You're still muted. Just hold down your space bar. There you go.
Can you
State
hear
your
me?
name. Yes,
Lewis
I can hear
Howard.
you now.
All right, Lewis Howard Goodine.
All right, what are we doing on this?
Your Honor, Mr. Childers and I have talked. We are asking for an examination on June 16th, please.
For what date? I don't.
June
That's a
16th.
Monday.
16th.
I didn't ask for that.
Well, you don't pick your dates, you know that. And June 16th is not a date we do exams.
Oh, I was told you would do it at 1 o'clock that day. Okay.
The 17th is a Tuesday.
But he's saying at 1 o'clock. We don't set them at 1 o'clock either.
Candidly, Your Honor, Mr.
Well, there will be exams set at noon on the 17th.
And Mr. Burkett called me asking about a later exam date, and I said, you can have that discussion with Judge Simpson, and I gave him the heads up. If it's set for the 17th, that would potentially not be in the morning.
That's what I was thinking.
Preliminary examination will be set in person June 17th, 2025. That's at 12 noon sharp, Mr. Burkett. That's before me.
Thank you.
Bond continued. Court calls case people versus recall Darian Cotton.
Andrew Childers, appearing on behalf of the people.
Okay, we're still having a problem hearing you, but I think I got most of that.
Sorry.
That's better. Mr. Cotton, can you state your name?
Darian Cotton, Your Honor.
All right, what are we doing on this? That'd be a correct statement.
Sure.
I'll adjourn it out June 5th, 2025, 9 a.m. Whereas your invite indicates bond continue.
Mr. Kizzy, give my office a call close to that date so we can confirm things. Come to court.
Understood. Thank you. And thank you, Your Honor. Good to see you.
Thank you.
Thank you, Your Honor.
Court calls the case, recalls case, people versus Marissa Bridgman.
Good afternoon, Your Honor. Marissa, assistant prosecuting attorney.
I appreciate the recall, Your Honor. Sam Burnside from Marissa Bridgman.
Hi, Marissa Bridgman.
Thank you.
Your Honor, discovery is complete. We're asking the court to please set this for exam.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Washington. Thank you, bond continue.
Thank you. Have a good day.
Thank you. Case of the people versus Mark White.
Good afternoon, assistant prosecuting attorney on behalf of the people.
David Knopf, appearing on behalf of the defendant, who is present, Your Honor.
Yes, we have a PCC up, but also this is your motion.
Your Honor, we're withdrawing the motion on bond.
On bond? All right. Sir, state your name. All right. Okay, so what are we doing today on this?
I think we're pushing it off to another PCC for the prosecutors handling the case to be here.
Okay,
Okay, since I don't know everybody's schedule, when might that be?
that's a good question, Your Honor. If she is requested to be here, she will be here. I'm not sure.
So,
Middle of June?
well, why are we waiting? Well, hold on. Why are you saying the prosecutor handling the case? I mean, because they're all,
I don't think he likes me, Your Honor.
No, that's not true.
Do you want to talk about resolution? Is that why you're adjourning it?
No, we will set it for prelim.
Okay, if there's any confusion, we can't prosecute a shop, so if Ms. Willenbring is here and available, she will be here. It is assigned to her. If she is not, it will be covered. But I do need to know if we're adjourning or setting it for exam. You might be unlucky and get me anyway, so.
No, I mean, I had thought from our prior conversation that you didn't want to.
No, I said.
Why do I-
Okay.
Why do I feel like a third wheel on a?
Your Honor,
You want to set it for prelim? Let's set it for an exam. On rock and roll.
Your Honor, may we pass so I can have a discussion with defense counsel about what he wants to do in this?
pass it. I think you guys do need to talk, like when council gets up here and playing games like this. Let's go, let's talk about it, figure out what we're gonna do, and let's move this ahead. You can have a seat, Sarah. That's it for 2:00, then I can leave here and then I don't have to come back, I come back. I have 3:00 left, okay, so. Cool, get a break. Of course, then recess.